All right. Let's see. How's it going, everybody? Whew. Oh, one more. Gotta do one more thing. I always forget one, right? Okay, happy Monday, everybody. Excuse me. Come on. Supreme Court website's giving me a spinning circle, which does not mean it's connected. So let's try that again. Can't tell if it's on or not. I guess we'll see in a second. Oh, we are still missing. Hold on, talkers. Let's get you. Into my morning, Max's mom. Morning, Cece. And I hope, let's see if everything's. Here we go. I think everything is a go. Whew. Now we just gotta wait for the court to catch up. Oh, wait, I have one more thing. Something just went screwy on me. Not on your end, but something that I really wanted. Hopefully this doesn't screw anything up. Morning, Vashon. There we go. Okay. There we go. Hi. Make sure I can see everybody properly. Whew. I am still re-waking up a little bit. Awesome. Checking out the tubes this morning. I think it's a slightly cooler view. Yeah, Wednesday's going to be a cool one. Oh, tomorrow's an opinion. Wednesday's an opinion day. Okay, good. Speaking of, let's check and see.
We will hear
argument here we go.
first.
Can you guys hear?
Case
Sorry. Are we back? Sorry, guys. Fix that. Whee! Here we go. Sorry
So
about that.
under your view, what's the difference between disgorgement and compensatory damage?
The back?
I think there's an important distinction. Disgorgement is about identifying an asset before the court that rightfully belongs to someone else. Damages are seeking to make an injured party whole. So in some cases...
So I thought you were pegging your argument to the existence of an injured party.
Oh, we certainly are, Your Honor, but you need some party with a right or entitlement to the proceed, to the asset before the court, in order for disgorgement to have a compensatory function. Now, it is possible that in some cases disgorgement and damages will overlap, but there are obviously important distinctions, including that disgorgement is capped by net proceeds. And again, if an injured party is only entitled to part of the asset before the court, then disgorgement is limited to that part of the asset. If you go beyond that, you cross the line into a penalty and a windfall.
Well, let's take a step back. You seem to rely quite a bit on loot, right?
That's right.
The world has changed in this area since Lew, and disgorgement is now in, what, Section 7?
That's correct.
And it has a different
Thomas does not like
statute of limitations. And
these equitable remedies.
Do you think it's still an equitable remedy?
Oh, absolutely, Your Honor.
It's not in the equitable section, which is Section 5, right?
It's not in Section 5. Congress gave it a new home in Section 7 so that it could make
Well,
sense.
as far as I was concerned, it was homeless to begin with.
Well, you're not necessarily wrong, but, in light of the court's reading in Lew, it said disgorgement is an equitable remedy. And Lew is very clear about what Congress needed to do if it wanted to expand disgorgement beyond its traditional bounds as identified in Lew. And it said that if a statute only takes the word disgorgement, that does not expand the traditional bounds of the equitable remedy, yet that's exactly what Congress did here.
Can we talk about the traditional bounds, though? Because I didn't see any case that you're pointing to that suggests that pecuniary harm was a requirement traditionally. So can you help us to understand where that's coming from?
Sure, I think it actually, if you look at both at Kokesh before Lew and Jarkissi after Lew, and the cases cited in Lew itself, disgorgement is always tied to some party that has a superior right or entitlement to some kind of proceed. So it could be a pecuniary harm. Someone has been injured and the proceed that the defendant now holds is rightfully theirs. It could be a situation like copyrights or patents, as we saw in the Sheldon case, where the court says someone used the property and part of the property right comes with a right to the proceeds. So that if you don't return the proceeds, then in fact that is a loss, that is a pecuniary harm.
I understand, but in Lew, didn't we leave open the question at issue here? I mean, didn't we say that the parties have not identified authorities revealing the traditional equitable principles, what traditional equitable principles govern? For instance, the wrongdoer's profits cannot, when the wrongdoer's profits cannot practically be dispersed to the victims. In other words, in a situation in which you have disgorged the profits, but it is impracticable or infeasible to give them to the victims, we left open whether or not disgorgement was still available under those circumstances. So why doesn't that cut against your view that traditionally there would be no disgorgement available?
Your Honor, that was the language addressing feasibility is addressing a very limited exception where there happens to be, for some reason, we can't get money to the right party.
No, I understand, but your argument is that there is no disgorgement in a situation in which there has been no harm to the parties. There's no, to the victim. And I appreciate that you say this is a different circumstance. It's where there's been harm, but somehow it's infeasible to get the money back to them. But it does seem to me to cut against your view when here we've left open whether or not disgorgement is available in a situation in which the money is not returnable or can't be returned to any victims, or maybe when there is no victim in any meaningful sense.
Your Honor, I wouldn't let the tail wag the dog. That is truly a very limited, unusual exception where you have a situation, for example, where each shareholder is entitled to 25 cents, and you can't figure out how can we even put the stamp on the envelope to send them the money. Now, if you look at Part 2 of Liu, I think it does in fact provide the exact analytical foundation necessary to decide this
Does
case.
it provide a case that says that pecuniary harm was a requirement under traditional equitable principles?
Well, what it said, Your Honor, is, and I think if you look at the different predicates that go into Liu, I think this does establish this. It can't be a punishment or deterrent. And in fact, if you're providing a windfall and you don't have a compensatory function, then you are punishing and you are deterring. And then you're simply taking a
Why is it a punishment if we're not taking anything more from the defendant than he unlawfully gained? In other words, I could see a fine or a punishment if the defendant is actually paying
all they're
out
taking
of his
is his
pocket
profits, not
some money that was rightfully his. That's a
ill-gotten
punishment. But
profits.
if we're just disgorging his ill-gotten gains, I guess I'm not sure I understand why that's a punishment.
I think two key answers, Your Honor. The first is that it's still depriving the wrongdoer in the same way that a penalty is a punishment and does deprive the wrongdoer, even if it's only targeting, say, half of his net gain. It's still a punishment.
It's depriving him of money he didn't have, that was never his. Why is that a punishment?
It's a punishment because the purpose is to deprive and the purpose is to deter. And the court was very clear, both in Liu and in Jarkissi, that if the purpose isn't remedial, if the purpose isn't to restore funds to the proper owner, to the wronged party, then in fact it does cross that line into a penalty.
Mr. Geiser, I'm a little bit confused by your argument, okay? On lots of levels, but let's start with the first. At one point in your brief, you agree that disgorgement should be measured by the defendant's wrongful profits rather than the victim's losses. Do you agree with that?
We agree that that is part of the equation, Your Honor.
Well, I don't know why it's not the whole equation, meaning one of the reasons to do disgorgement instead of a victim coming to prove losses is because sometimes it's hard to quantify the loss, so you use an alternative, disgorgement, correct?
Well, yes and no, Your Honor.
You can't do both, right?
You can't do both, but
Right, and you can't do both because I thought that what you're compensating is the invasion of the legal right, correct?
yes, but I think
Let me take you step by step. So you're not debating that the victim's legal rights were invaded here, correct?
we're not debating that they had a legal right invaded. We are debating that they have a right to the proceeds in question.
Yeah, the problem I have with that is that we've said, and Justice Thomas himself said in
Gustav, I think that's
Lehman,
dead
that,
on, but then it
even
discourages
with
people
profit-based
from
remedies,
doing
without a showing
this
of
work without
pecuniary
registering. And the
loss,
purpose of
can be
requiring
included in
registration
the compensation of compensatory
is
relief.
there's a pretty strong reason to require
The whole idea
registration.
behind lost profits is you took my money and you made money from it. You're not entitled to that because you invaded my right to have that money. And maybe I wasn't as smart as you or as corrupt as you, and I didn't make that money, but you took it from me. You invaded my legal rights. So I'm entitled to be compensated.
I don't think that's quite right, Your Honor. When you're entitled to lost profits is when there is some legal right or entitlement that gives access not just to the property, but to the proceeds from the property.
So what normally gives right to
Well,
disgorgement?
who knows?
Well, what normally, if you look at a case like, think about patents or copyrights. You have a right to the patented invention. You have a right to the copyright, the inventor.
So you're thinking that slew of common law cases that weren't patents or patent cases where lost profits were the measure of loss for victims, that those were all wrong?
No, not at all, Your Honor. In every single case that I think the government cites and the government's amici cite, it involves a situation where the party before the court who's asking for disgorgement says, I have a legal entitlement, a legal right to those proceeds, That's very different than this situation where Congress made a determination looking at these very victims in this setting with this type of harm, trying to get these proceeds that they would lose. They have absolutely no legal entitlement to the proceeds in this case.
So is your position, and you said it in your reply brief, and I'm a little confused by it, that in your reply you say that if there is only provable loss of $1, then the maximum measure of disgorgement is $1?
That's exactly right.
So basically what you're saying is the government has to call every victim, prove every dollar of loss. Why bother?
Well, Your Honor,
Why bother asking for disgorgement if they have to prove loss to that amount? I thought disgorgement was to make it easier as an alternative.
No, Your Honor, not in this context. And again, remember the context. This is the SEC, who's a stranger to the transaction, who has the option while they're enforcing the security laws, and they can seek penalties where they can get full gross proceeds from the wrongdoer. If at the same time they want to try to compensate the victim, then they can seek disgorgement. If they think it's difficult to add up those losses and to figure that out, one, seek civil penalties.
So does this all come down to, is the SEC going to keep the money, or if the order says you pay it to victims, if they say you pay it to victims, then they can do this?
Your Honor, I will say what the court said in lieu, which is you have to provide fair compensation to the person wronged. Fair compensation doesn't mean a windfall. It doesn't mean exceeding the amount of right that the person has to the proceeds. This is a compensatory remedy. It's about restoring the status quo, and it's about not providing windfalls.
I'm sorry, finish what you're saying.
No, please.
Well, putting aside the question whether after Congress's most recent enactment, disgorgement under that provision has to be equitable. Let's assume that it still has to be equitable. There were forms of equitable disgorgement, right, including an accounting for profits. And you say that under under such a claim, the victim has, quote, an underlying substantive entitlement to the profits. So why doesn't the SEC have a substantive entitlement to the profits after the enactment of the current statute?
Well, because I think all the current statute does is give the SEC the right to seek disgorgement, as this court then necessarily defined disgorgement in lieu as an equitable remedy that can't be a punishment, it can't be a deterrent. And the SEC is not seeking disgorgement for itself. It's seeking disgorgement for the injured parties. And again, I think under that reading, Your Honor, if you do look at disgorgement as simply saying we can deprive the wrongdoer of an ill-gotten gain, first, that's the first principle in lieu. That was checked by the countervailing principle in lieu, that it has to be a compensatory remedy for a victim. The SEC is not the victim.
You got love from
And you also have a situation where you collapse the distinction in D3 between civil penalties and disgorgement. I don't think the court has to go beyond the four corners of this statute to read the language the way that we're reading it. Congress delineated.
Well, the statute, as it currently stands, doesn't say equitable disgorgement. It just says disgorgement.
And disgorgement by its very nature is equitable.
I have a couple of examples I want to throw out to you guys, but I need to wait for a little bit of a pause.
Forms of disgorgement, were there not?
I don't believe so, Your Honor. Disgorgement, as Liu explained, is by its very core is an equitable remedy. So I don't think you can say that, in fact, that this is now a second form of punishment. And if you do read the statute that way, then you're collapsing the distinction between penalties and disgorgement, even though Congress delineated between those two things. Under our reading, each has a separate function.
If I could just interrupt you, I just want to make sure I understand it, and this goes back to Justice Thomas's first question. You're saying that there is no situation in which disgorgement is appropriate where compensatory damages would not also be appropriate. Is that right? That disgorgement can never go above compensatory damages?
No, Your Honor, and I do want to be clear about this. There are some situations where, by the nature of the way damages are calculated, an injured party could be better off by seeking the net profits, the net proceeds, instead of seeking a damages remedy. But the two overlap.
Well, tell me where we're talking about, because the only thing I've heard from you is situations in which disgorgement doesn't come up to the level of compensatory damages. But how could disgorgement, in your view, go over the level of compensatory damages?
I think if you look at the copyright and patent cases, like the Sheldon case, those are examples where someone, for example, might have written a play, but they absolutely have no ability to produce a movie on their own. A studio comes in, misappropriates their protected copyrighted play, and you might want to seek the net profits from that, as opposed to trying to seek damages because you couldn't sell your play to a studio for the same amount. So there are situations where you could see daylight between the two, but I think what really matters here is that if you look at what Congress was trying to do And when you pair disgorgement and penalties in the same subsection, they must have different functions. And I think those functions collapse under
You're
my
saying, well,
stance.
disgorgement and penalties. I guess what I'm focusing on is disgorgement and compensatory damages, because my understanding of disgorgement, you said it's an equitable penalty, it's an equitable penalty. So it was, that it was meant to operate in places where compensatory damages would not operate. That's the whole point of it being equitable. You couldn't get it legally at law, but you could get it by way of this equitable road.
Sure, Your Honor, but in all of those situations, what you're trying to get is you've
Frog,
identified
the
some
casino
asset,
made
property,
money.
funds, money, whatever it is, and you say,
All of
I
their
have a right
profits
to
they're
that
having to
asset
give back.
because I have an underlying substantive right to it, either as a matter of property, as a
Even
matter of
though
patent, as a
the
matter
people
of
playing the games
trusts
actually
and
broke even.
beneficiaries of fiduciary law. There's something that gives the injured party the right to the asset in the same way that if I put $100
sense?
into an interest-bearing bank account and the bank returns $100 to me without the interest, I think I've suffered a loss, and I can seek to recover that interest. That's all those cases say. And you could have situations with damages where you've suffered beyond net proceeds. You could have situations where your tangible concrete harm might be less than the gain that someone produced by misappropriating something that belongs to you. But again, what we're dealing with here, though, all of these, in every single case, the remedy is in fact compensatory. It's not designed just to
Compensation.
deprive someone of an asset. It's designed to
You lost
compensate
if they
an injured
lost
party.
money.
And
Pay
again,
them
that
back.
makes sense if you look at the statute
is
with
different.
under D3.
Has nothing to
And
do whether
especially
they
if you
lost
fast
money or
forward
not.
to D9.
But what about the fact that the compensatory language and the focus of Liu with respect to compensatory
He's saying they
seemed
didn't lose any
rooted
money. We
in the
shouldn't have to
language
give.
of
I shouldn't have to give them
D5.
anything back. I'm a casino. I
That
shouldn't
at
have
the
to pay them
time,
any money.
Justice Thomas mentions this, that D5 was the only thing on the books, and we say in Liu that this is really about the, quote, appropriate or necessary for the benefit of investors language, which appears in
Careful
D5,
with that,
but
Rashawn.
not in D7.
Exactly, Your Honor. That comes in Part 3 of the opinion. And if Part 3 were the
kind of
only
the-
part of the opinion, I think this would be a harder case for us.
Careful with
in
that.
Part 2, the court is focused exclusively on traditional equitable rules. It has nothing to do with the language of D5. And even when
Is
the
it
court
really
did
more
get to
the
Part D5 in Part
goal of
3,
contract
it stressed,
law,
if you look at page 90, it said
A lot of
it
things are
applies
about making
both
people whole.
because of the
Actually,
specific
tort
language
law,
of
never
D5
mind.
and traditional equitable constraints.
Counsel, can I, oh, sorry.
Please, go ahead.
This kind of dovetails with Justice Jackson's question and goes back to Justice Thomas's question. Let's say that I don't read Liu the way you do. Let's say that I read it more like Justice Jackson was just proposing. Do you then say, well, I still win because just the word disgorgement, even though it's been taken out of D5, still has these traditional equitable limitations? So is Liu kind of unnecessary? Obviously, it helps you if it squarely would require us to decide this case in your favor, but take Liu out of the equation. Tell me why your argument would still carry the day.
Well, I think we can win in any of 3 independent paths. First, if we want to relitigate first principles about what disgorgement means and how it functions as an equitable remedy, I think we can win on that. I think if you read Liu our way, and then you understand that Congress ratified Liu, which I think is the only plausible way to understand what Congress did when it takes a term this court just defined, I think it's taking this court's understanding of that term, not some scattershot body of district.
Okay, but you're going back to Liu, if you can't rely on Liu.
If I can't rely on Liu, then again, I think we can do first principles, or you can just look at the statute itself.
don't do
I think
that.
the best reading of the statute
talk in
when
a
you
bit.
pair civil penalties with disgorgement is you have to delineate between the two. They each have to mean something different.
I'll make a note.
Under my friend's reading, Congress would have simply rewritten the statute to say the SEC can seek civil penalties up to gross proceeds, net proceeds, or both. Because that's how they read the idea of disgorgement. It's simply about taking away the asset. We read it to have a remedial
But
function.
penalties don't have to be limited to net proceeds or gross proceeds. I mean, penalties could be entirely detached from that.
Oh, absolutely, Your Honor. But my point is, though, that the way the government is understanding the addition of disgorgement to D3, it's indistinguishable from a second penalty.
Okay, last question. The Ninth Circuit said that your victims or your client's victims had suffered a violation of their legal interests. You agree?
Of their legal interests, but that does not give them a legal right to the proceeds. Those are two different things, and
Right.
we know that from other provisions of the securities laws. If they filed suit saying we have a right to the proceeds, unlike the plaintiffs in all of the other equity cases that my friend cites, the investors here would lose because they have no injury.
Frog, let me know if I
And
clarified
I
for
do
you
just
at
want to
all.
also supplement this, because if the court does just want to look to the statute, I think the easiest way to resolve a statutory case is sometimes to look at the statute. One thing we haven't talked about is D9. And in D9, and this was an addition that Congress included when it added D7, the Congress made clear that the fact that we are now empowering the SEC to seek disgorgement does not mean that we're precluding the ability of a private investor to file their own lawsuit. Under my friend's understanding, that is a very odd provision. Why would Congress be concerned that a remedy that simply lets the SEC deprive a wrongdoer of an ill-gotten gain? They don't have to give it to anyone. They don't need to show any harm. They can just take it. Why would anyone even think that might preclude the ability of a private litigant to file their own lawsuit? But under our reading, where disgorgement is designed for a compensatory function, where the SEC invokes disgorgement in order to compensate an injured investor to stand in their shoes and seek recovery on their behalf, that's where Congress would be concerned. That now that we've armed the SEC to do this, maybe a court might think that private parties can't seek that identical relief on their own. So I think if you just look in the four corners of the statute itself, I think we have the better reading. I think we certainly have the better reading after Liu. And respectfully, I really do think if you read Part 2, it says there are two principles. One is you can deprive a wrongdoer of an ill-gotten gain, but then it said there's a countervailing principle. Countervailing, the idea of that term is it's cutting back or restricting. And the countervailing principle says you have to provide fair compensation to the person wronged so that it does not cross the line into a penalty. Under my friend's view, this is a penalty. This is taking an asset that someone has and it's depriving them of their asset for the sole purpose of depriving them of what we don't think they should have. We're casting judgment and to deter someone from breaking the law in the future. If the SEC wants to seek that kind of remedy, they have the ability to do it. Invoke a civil penalty, but then you have to provide a jury trial. You have to satisfy under the facts and circumstances that they're entitled to that kind of relief, and they can't just do an end run, which is, I believe, what the SEC is doing now. If all you need to do to get a disgorgement remedy is come to a court, you don't need a jury trial, you can overestimate the amounts of the gains, as they did here. They asked for over $4 million, and the court found over $2 million of that was inflated, and then you coerce defendants to settle, because they don't have much of an option when they're facing that kind of demand from the government.
I'll explain why as soon as I get a second. Okay, Infinity Forever. Imagine a bank that holds your money for a while, and you come and try to get it, and they're like, oh, we have to hold it for an extra week illegally, and in that meantime, they invest it and make money off of it. Okay? Money that's held makes money. So he got money that he shouldn't have had and would have made more money off it. So now we're making him give it back to them.
Money that they
Does that make sense?
In other words, didn't he aim to obtain money from? Weren't those people? Wasn't it his intent to make them victims?
Your Honor, I don't know if that was his intent or not. What I do know,
it's inherent in the scheme, is it not?
Well, but you still need to have an actual injury to seek compensation, which is why if those investors, if an uninjured investor, even if a wrongdoer says, I'm going to target you and I'm going to try to get your money, I'm going to try to trick you into buying the stock. If the stock price goes up but it never drops, they don't have any injury. So Congress made the determination that those investors are not entitled to recovery. The very recovery that the SEC says as a windfall, they are entitled to.
Well, is it your claim that they didn't suffer an injury, or that it's just too hard to prove that they suffered an injury because the stock could have gone up and down for a million other reasons?
You know,
could have.
In
They
this
could have
case,
lost
the
tons of
contention is
money
the SEC
because of
didn't
what he
prove
did.
that there was an injury at all. And if you look to
he got
on
lucky and
page
they didn't.
10A of the appendix, footnote 4, the Ninth Circuit cast doubt on the SEC's ability to show any injury here because they proved an artificial inflation but no drop. But our contention below, and this is if you look at page 28 of the record, is that the SEC also didn't do the work that it has to do if it wants a disgorgement remedy under a proper reading of disgorgement to actually track down who is owed what so that the disgorgement order doesn't cross that line into a windfall and a penalty, which makes it impermissible as an equitable remedy.
Justice Sotomayor?
I know you think you can win on 3 grounds, and I don't want you to panic. But assuming you were to lose, there's 2 grounds. One would be that disgorgement as an equitable remedy never required proof of pecuniary loss, and there's certainly quite a bit besides Restatement 3, quite a bit of treatises and cases that support that conclusion. Or we could say that 78 UD7 has taken out any equitable, doesn't require pecuniary loss because it's setting forth just compensable legal invasion of a legal right. Which of the two would you prefer to win on?
So,
Or lose on, I'm sorry. Lose on.
well, I would prefer to win on any of our three
Yeah,
grounds.
no.
But if we lose, we lose, Your Honor. I think you can write the opinion however you'd like. But I'd like
Wouldn't
to
it
try to
make it
take on.
easier if we wrote
$6
it
million.
as that 78 UD7 is different? Because then your pecuniary, your penalty argument would be stronger for your Seventh Amendment claim?
So possibly, Your Honor, but I want to try to also just give the court some guidance on the collateral damage that could happen depending on how you write the opinion. So if you were to write an opinion against us, it says that when Congress used the word disgorgement, the word that this court had just defined in lieu, that Congress was adopting the rejected, repudiated body of lower court decisions instead of this court's understanding of that term. I think that's going to create a lot of confusion about what Congress needs to do in the future when they're trying to ratify this court's decisions. I don't think that's how Congress would have acted, especially after Liu made unambiguously clear. I think for whatever disagreement we have about what Liu means, there was a sentence in Liu that said, if a word appears in a statute, if the word disgorgement appears in a statute, it does not expand it beyond its traditional common law bounds. And that's exactly what Congress did here. So I think
But it
that
didn't
path will
just-
create
it didn't-
confusion.
It didn't do just that. It just took parts of what Liu said and didn't take other parts of it. It took limiting damages to what this defendant has done. It took the word disgorgement, but it didn't take the language we actually analyzed, which was payment to victims.
Your Honor, that language that Congress didn't take is embedded. It's implicit in the definition of disgorgement. There was no need to include that language, and I think that argument would be stronger.
Why did we bother analyzing that? Why did I bother analyzing that language in lieu?
Well, I think Your Honor could
Why so much emphasis by me in lieu on the importance of that language to our determination?
Your Honor, I think that Your Honor did a wonderful job in Part 2 of the opinion, which would have been
suggest I
sufficient.
didn't in
That's,
Part
I think,
1.
And then Part 3 was the belts and suspenders. Now, I think that that
it's
argument would make a
profitable
lot
until
more
you get
sense
caught,
if
so
D5
that's
said
why we
disgorgement for the benefit of investors.
have
Now, that
these
would be
big
entirely
requirements.
redundant. The reasons Congress doesn't speak
And it is
like
so
that.
important to
But
enforce
D5
these,
says
because otherwise
equitable
you have
relief
market
for the
crashes
benefit of
that
investors. That's the entire
wipe out the whole
universe
country.
of equitable remedies
Thank
cabined
you,
down.
counsel. So you don't care which way.
Well, I
Is
care a
that your
little,
bottom
but what we're trying to do is both construe the common law correctly, and to be very clear too, because I do want to.
Counsel, assume you're losing. Which of the two arguments would you like to lose on?
Well,
I don't want you to backtrack into why you should win. I want you to give me a clear answer, okay?
well,
That just went on my
Your Honor,
t-shirt
I
list.
think to explain which argument we'd prefer to lose on, it helps to actually march through what that would mean. I've explained why I think the statutory argument would be dangerous. I think the common law argument would also be dangerous and create confusion. All of the cases that you're suggesting that don't involve a pecuniary loss, they involve a legal entitlement to the proceeds, and that doesn't exist here. So I think Your Honor is going to have a difficult time squaring.
That's assuming that 78 UD doesn't give them, D7 doesn't give them that legal entitlement.
If it gives a legal entitlement that changes and redefines the core definition at its irreducible core of what disgorgement is by simply
That
using
one
the word
hurt.
disgorgement, then I
That
think
one
Congress is
burned a
going to
little.
be very confused on how to write statutes going forward.
Okay. You still didn't give me an answer, but thank you.
Justice Kagan? Justice Gorsuch?
Just to follow up on that briefly, Mr. Geiser, is it fair to assume that Congress legislates against the backdrop of the common law?
I think so, Your Honor.
And is it fair to, when it uses a word like disgorgement that we just used in lieu, do we usually assume that Congress understands what we've just done?
Yes.
Yeah, and so the linkage between that and having to prove that there's investors out there who've been injured, not injured, their money their legal right taken, causally connected and identifiable, and return the money to their benefit, at least where it's not infeasible. We would understand Congress to have meant all that when it used the word disgorgement, don't you think?
I absolutely do think.
Thank you.
Justice Kavanaugh?
On your first principles argument, do you want to respond to the amicus brief of the professors, Laycock and others, on that succinctly? Because they say you're
I know. No idea what's happening. Sorry, guys. Everybody back? OBS keeps my
to that asset. And we're just disagreeing with what we're calling that sort of missing profit. But that doesn't change the analysis, it just changes the terminology.
Next question. What do you think Congress was trying to accomplish in 2021 when it enacted that statute?
We think that the best reading is they were trying to reattach a limitations period to the SEC's disgorgement authority. And the government doesn't take issue with that point. They agree that once Liu said that disgorgement has to be a fundamentally equitable remedy, it can't be a punishment, it can't be a penalty or a deterrent, that took away Kokish's holding that the penalty 5-year limitations period applied. So the SEC was left facing absolutely no deadline whatsoever. Now the government says, well, there are lots of ways Congress could have written that statute. I think it would be very strange to include, as the government suggests, a new limitations period for disgorgement, which at the time is a remedy that isn't mentioned anywhere in the statute. As a matter of simple housekeeping, it makes far more sense to say we're going to create a new limitations period for disgorgement. So we need to include disgorgement somewhere in the statute so that we're making clear there's something here that the SEC has a timeline on which to seek.
Last, do you want to say anything about Seventh Amendment implications of the government's position, if any?
I think that the government kind of has a difficult path no matter how they answer that question. I'm guessing my friend is going to say that their version of disgorgement, despite looking entirely penal, will not be subject to a jury trial. The Seventh Amendment rights won't kick in. I think if they take that position, then that shows the SEC is trying to set up a penalty with an end run around an actual penalty in the statute. And if the government does concede now that their version of disgorgement would require a jury trial, that just further collapses the distinction in D3 between disgorgement and penalties, which are two very different terms, different concepts. I don't know why Congress would have added disgorgement if all it's supposed to do and all it needs to do is simply deprive the wrongdoer of net proceeds. That looks like a penalty just with a different cap.
Thank you.
Justice Barrett?
Why does that look like a penalty? If all you're taking away is the ill-gotten gains, so they're the proceeds that the wrongdoer isn't entitled to in the first place, as opposed to being entirely punitive because it's going above and beyond, why would that necessarily be a penalty?
Anything is a penalty if the point is to take it away from you. We're making a judgment that you weren't entitled to this, so we're taking it from you. What makes it remedial is you're giving it to the right party. But that means there has to be a right party to give it to. There has to be some party with a right to it. And again, look to Liu, and if you don't like Liu...
I like Liu.
Okay, well, I'm sure Justice Sotomayor will appreciate that.
I don't necessarily like your reading of Liu, but
okay.
I like Liu.
Well, then hopefully you'll like, again, my reading of Jarkissi. Jarkissi is crystal clear. Look at pages 123 and 124 of the opinion. It's dividing that same line between a legal remedy and an equitable remedy. And it says that something is a punishment if it's not restoring the status quo, which means returning the funds to the injured investor. It's not enough just to deprive. If you deprive, that crosses the line into a punishment. And again, I don't think that the SEC could credibly say, we're not trying to put you in the red. We don't want gross proceeds. We're just going to take away net proceeds or half of net proceeds. Suddenly, it's not a penalty. It's not a punishment because we're not going in, over the line into punitive damages. It's about the point of taking it away, both to deprive someone, to deprive someone is a punishment, and to deter. And again, my friend in his brief, he's very clear. The purpose of taking it away is to punish and deter. Deterrence, as Kokish said, as Liu said, as Jarkissi said, all of these cases agree. Deterrence is a penal function.
Justice Jackson?
So I guess this idea of trying to characterize something as penal or not is confusing in this context, because I had understood the relevant distinction to be between compensatory damages, which is the idea of making the victims whole, versus disgorgement, which is divesting the defendant of the ill-gotten gains. And one thing that you haven't touched upon at all is the very traditional equitable principle of unjust enrichment, which would seem to me to fit squarely into the equitable concept of depriving the defendant of their ill-gotten gains. And that, I thought, was what the scholars were talking about. That is a traditional equitable principle, not a legal one in the way that you've been defining it. I guess you could characterize it as a penalty, but it doesn't seem to matter, because traditionally, courts have been able to exercise their equitable authority to deprive the defendant of ill-gotten gains, which they term unjust enrichment. So can you speak to that?
Sure. I mean, and I apologize if I sound like I'm repeating myself. Jarkissi and Liu make clear that if that's all you're trying to do is deprive that ill-gotten gains, that's the first principle that Liu identified. But Liu said there are two principles, and one is a countervailing principle. To avoid making that punitive, which is where Jarkissi comes in, Jarkissi makes absolutely clear.
So you're saying unless we do this in the way that you're talking about, the Jarkissi case, which is not a common law, I mean, it's like our case from a couple years ago, right? The idea of the Seventh Amendment is what we're avoiding with this concept. I just don't understand why the first principle isn't all we need with respect to resolving the issue in this case.
Prashant,
me
I
try
missed
it
the
this
first
way.
thing she said.
I
What
think
would
that
she
it's
say
a
was,
very traditional principle
opposed
going back
to
centuries, if not
disgorgement?
longer.
What was her
millennia.
first example?
We cite a
that was more
Roman
legal?
case in our brief. Is that equity doesn't serve punitive functions. The role of equity is not to penalize.
All right, but
it's
what
not to
about the
deter.
unjust enrichment concept? Do you agree that that was an equitable concept? Unjust enrichment, you're not, no, it's not?
No, it is. Unjust
Okay.
enrichment.
So what does that mean, unjust enrichment?
In the statute, unjust enrichment.
No, in common law, what does unjust enrichment mean and allow the court to do?
The unjust enrichment has, I think, two components. One, someone has to be enriched, and they have to be enriched unjustly. Now, in order to recover the unjust enrichment, you need to find some claimant with an entitlement to those proceeds. Equity doesn't award windfalls. I can't come into court as a random stranger saying, hey, I saw someone do something wrong.
And this is, my time is short. How does finding the claimant and identifying their loss help us to know whether or not it was unjust enrichment from the standpoint of the equitable determination that this defendant should not be allowed to retain this amount of money?
Your Honor, the reason you find those victims and determine their loss is because that's the core function of disgorgement. It's to get the asset from the person who shouldn't hold it to the person who should.
Thank you.
Thank you, counsel.
Thank you.
All right. Lawyer number 2. And by the way, yeah, guys, I'm sorry. The program that streams all this for me, that pulls it all together, has crashed on me twice today. It has never crashed the entire. That has never happened before.
What
So
petitioner is trying to accomplish here. Petitioner is attempting to make it as difficult as possible for the SEC to pass disgorgement awards over to victims, and petitioner is trying to do that by urging the court to adopt the narrowest possible conception of victim. And then second, petitioner is asking the court implicitly to resolve in his favor the question that this court left open in lieu, namely, if it is infeasible to pass disgorgement along to victims, can the money be put in the Treasury? And only by succeeding in both halves can petitioner prevail. And so even under subsection D5, this goes well beyond anything that the court held in lieu. The second thing is, it's just wrong to say that the court in lieu interpreted the term disgorgement. The court had no occasion to do that because the term disgorgement didn't appear in the statute, D5, that the court was applying. When the court said, under traditional equitable principles, the government has to, in order to collect disgorgement, the SEC has to pass funds along to victims if it is feasible to do so. The court didn't say, otherwise it wouldn't be disgorgement. The court said otherwise it wouldn't be consistent with what courts of equity have typically done. And if you look at dictionary definitions, Black's Law Dictionary, for example, you look at restitution and you see lots of entries about passing from a wrongdoer funds or property that rightfully belongs to someone else. If you look at the Black's Law Dictionary definition of disgorgement, you just see an act of giving up. It's the surrender, full stop. And so disgorgement is the word Congress would use if it wanted to make it as clear as possible that what we care about is getting the defendant to give up its gains, and that any question about where the money goes after that is secondary. And then the last thing I'd say very quickly, petitioner would fundamentally transform the disgorgement remedy from one that is designed to deprive the defendant of ill-gotten gains and is measured by profits into a compensatory remedy in which the measure of recovery is losses to the victims. I welcome the court's questions.
Let me explain to you what you meant when you wrote this.
If you would accept the notion that this is a legal remedy.
It might be cleaner, and we don't think our position depends on whether the remedy under D3A2 and D7 is legal or equitable. That is, as long as we were operating under D5, which refers specifically to equitable relief, then we could get disgorgement under that provision only if we could persuade a court that it was equitable. But the whole thrust of what Congress did in 2021 was to say, we want the SEC to have a remedy that compels the defendant to give up its profits on the following conditions, whether that is regarded as legal or equitable. And so the question whether it's legal or equitable may have implications for whether you get a right to jury trial, but it doesn't have any implications for whether you can get the remedy at all.
But doesn't it look a lot less like an equitable remedy if you keep most of the, what percentage of the disgorgement do you keep now? Does the SEC keep?
I mean, I think we pass along a high percentage
There's
of
a question from
monies
earlier.
that are actually recovered. Now, the figures that are cited in petitioner's brief were not, I think it's on page 8. They cite a press release and they say it shows that $6.1 billion was seized in a particular year. In fact, that was the amount that was ordered disgorged, not the amount that was actually collected. So my understanding is something like 88% of funds actually collected were designated for distribution. I think the process takes time, and so that's not a guarantee that they would actually be distributed. But I think our practice is to distribute a high percentage of the funds we collect to people we regard as victims. Now, petitioner would make it more difficult for us to do that by saying the only victims we can legally distribute funds to are people who could establish their own right to sue under the private cause of action.
Counsel, several times in his opening brief, your friend looked to our recent case in Jarkissi, and we heard it cited several times this morning. You don't cite it at all in your brief. Do you want to talk about why it's not relevant at all here?
I mean, I think the reason we didn't regard it as relevant was that Jarkissi was focused on under what circumstances could the SEC impose monetary remedies in its own administrative proceedings. And here the question is, what can the SEC get when it sues in court? And so the SEC has to go before an Article III court. We have to persuade whoever the finder of fact is that there is liability. The court itself will determine the disgorgement amount. It won't be reviewing our assessment of disgorgement under a deferential standard. So it's not really the same question that was presented in Jarkissi.
Well, I thought his point was that your argument would treat the case as if it were a case like Jarkissi.
I mean, if that's his argument, I don't think it's right, because the whole rationale for the court striking down what was done in Jarkissi was that it had been done in an administrative tribunal acting without a jury rather than by a court. And,
No, I mean not for the jury question, but more in terms of how the sanction, whether disgorgement or
You
anything
Portuguese
else
girl,
was
I
treated.
appreciate it.
And the other thing that I would say is different between this case and Jarkissi is that in Jarkissi, we were recovering civil penalties, and civil penalties are often used to make the defendant worse off than he would have been if he hadn't engaged in the violation in order to create punishment and extra deterrence. And here, the disgorgement award is limited to the amount of the defendant's unjust enrichment, his net profits. It's limited to amounts that the defendant actually received as a result of the violation.
Mr. Stewart, just to follow up on the Chief Justice's questions, yes, Jarkissi concerned administrative proceedings, but it also concerned the Seventh Amendment. And so the question I think the Chief is trying to aim at
it's going to come up in tomorrow's case as well.
Okay, you've got this D7 remedy, but when might it trigger a jury trial right rather than remain before the judge in equity? And I just want to make sure I understand a few things. One, you agree that D7 is for net profits only, right?
Yes, and I think that's
Okay.
made clear in D3A. Looking at D7 by itself, you couldn't tell
Yes
that.
works for me.
Tomorrow we're going to talk about whether
Two, you agree
fines
that the
can
unjust enrichment has to be causally
invoke,
connected to the
Seventh
defendant's
Amendment
actions
jury
as a
right.
result of the defendant's actions is what you say in your brief, and you stand by that?
Yes.
Okay. And then third, and the kind of key one that I think your friend on the other side's been talking about is where the money goes after that. And to keep it in equity, you've got to get it back to the investors unless it's infeasible, we said, in lieu. And do you stand by that?
I would quarrel with that part of it. What the court said in lieu
So
of
you think you can get a disgorgement that without any effort to get it back to the investors and keep that in equity in front of a judge rather than trigger a jury trial right as a penalty?
well, that's a
Yes or no?
it's a two-part question.
No? It's a one-part question.
We would say yes, but there are. I think it's vital.
Yes, you can keep it in equity before a judge without a jury and make no effort to send the money back to investors?
That would be our position.
Okay, let's say that's wrong, okay? Let's say the equitable remedy was all about
that was-
restoring investors.
that was not the
Let's
answer.
say we think that. Then what?
Then I think it would follow that under D3A2 and D7, we can still get disgorgement without routing it to investors, but it would be considered a legal remedy.
And then a
therefore-
jury trial,
and
right?
then you'd
Oh,
have
so you
jury
agree
trial.
with that? So you agree that if you don't make an effort to get it to investors, there's a jury trial right?
We don't agree with that.
Well, hold on, which is it?
That's why I said it's a two-part question. We agree that the statute would permit us to get it without routing it to investors because D3A2 lists certain prerequisites and routing to investors is not one of them. Our position would be that would still be equitable and no jury trial would be available. I know there are arguments on the other side that not routing it to investors would
I
make.
think that's pretty perilous, Mr. Stewart. I think if you want to, if you want the equitable remedy, you gotta
That's not the
behave.
answer.
And without a jury trial right, all of equity, you got to follow the rules of equity. If you want a legal penalty, then the Seventh Amendment might have something to say about it.
Again, I'm
We
willing.
said that in lieu, right? I mean, and that is traditional equitable practice.
Well, in lieu, you said at the outset that when we see a provision that just generally authorizes equitable relief, we ask whether a particular remedy was typically available at equity.
Yes, and the government keeping all the money was not typically available at equity. It was getting it back to the investors. Now, maybe D7 authorizes that, but I don't see how it would not trigger the Seventh Amendment if the government just decided to keep all the money.
I think our argument would be along the lines of what Justice Barrett and Justice Jackson have suggested, that so long as the monetary remedy does nothing more than preventing the defendant from profiting by his own wrongdoing, so long as it simply takes away the illicit gains, then it's not a penalty and no Seventh Amendment right attaches, whereas the civil penalty provisions can make the defendant worse off than he would be if he hadn't committed the violation. But again,
Well, some penalties make the defendant worse off, others do not. Others can be very modest. It doesn't matter. You still get a jury trial right.
But Mr. Stewart, isn't your point that it's a penalty when it makes the defendant worse off? That's the point that Mr. Geiser keeps saying this is a punishment, but it's not a penalty or punishment if What is happening is the defendant is just being made to return the money that he never had access to, that was not his to begin with.
Yes, and what can happen in the SEC suits is if the court could authorize both disgorgement and a civil penalty, and the disgorgement would ensure that the defendant didn't profit from his own wrong, and then any civil penalty, even in a civil penalty in a fairly small amount, would by definition go beyond that and make the defendant worse off.
Mr. Stewart, let me try it this way. You're asking us to expand D7 beyond equitable practice to allow the government to keep the money. Do we have to decide whether that triggers the Seventh Amendment in this case? Can we reserve that question?
Yes.
All right.
Mr. Stewart, I wasn't, just to be clear, I was just pressing Mr. Geiser, not necessarily saying I agree with you. But I guess one question that I have is, how do we define disgorgement if not looking to the equitable piece of it? And actually, let me just back up and ask you, what is the government's practice with respect to distributing it to victims? Do you only try to restore them by calculating what they actually lost? Or do you give them a windfall?
I mean, I think it varies from case to case.
The thing is that it only applies to common law cases. Equity is not a common law case.
What you might call a windfall. That is, you could have a circumstance, for instance, if somebody, if a investment advisor lies about his credentials in order to encourage clients to sign up with them, and then the clients can't point to anything about the advisor's services that was actually deficient, but the SEC, having received disgorgement, may try to give the people who were deluded some portion of the recovery in order to compensate them for the fact that they weren't told the
But there are
truth.
circumstances in which the SEC would say, yeah, we're just going to return to victims what they lost so that we can keep the overage?
I mean, I think Mr. Geiser referred to one situation in which we might not make an effort at a distribution, and that is if you have violations that cause very diffuse harms, so the defendant may make a lot of money and may cause very small amounts of harm to a very large number of people, and the SEC may conclude that the administrative costs of identifying all these people and what each of them has lost is just going to eat up too much of the fund in order.
And that's the only situation?
I don't know that that's the only situation, and this has been our typical.
Do you know what others are? Because the figures from the last couple of years, as I have them at least, are that the SEC in 2024 had ordered disgorgement of over $6 billion and returned $345 million.
If you
Last year in 2025, it was $10.8 billion.
look back in
and
my
returned $262 million.
in my
Now, I know that's
playlist,
ordered.
I have an
versus
equity video from
collected,
about a year
but
ago.
Even if you're a reasonably
and the big
good
video I'm going to
collection
put out
agent,
soon has a
and the
huge
federal
chunk in
government
equity.
is a reasonably good collection agent, we all know. Let's say you get half of that. That's $5 billion versus $262 million. That's $3 billion versus $345 million. What kind of efforts does the government make to get this money back?
I don't think there's any reason to think that we get half of it. What I've been told.
You think it's less than half?
Yes.
How much less?
I don't know exactly how much less. I asked the question of, do we know what percentage of the $6 billion, $1.1 billion was collected, and we're not sure of the answer.
Well, so do you know that it is less than half?
It's a lot.
Or you just don't
more than
know?
I was
Well,
expecting.
I've also been told that of the amounts collected in, I think it was 2024, it could have been 2025, I believe it was 88% was designated for a distribution. That doesn't mean it would necessarily have
That's
been
more what I expected.
distributed at the end of the day, but that was something that we intended to do. And it's a long and time-consuming, both the collection and the distribution can be a long and time-consuming process. And
You're getting this from the SEC?
yes. I mean, the other thing I would say about the equitable
Because
principles.
the SEC has to
You're
pay for
representing
themselves.
88%
They have
of
to
the money
keep
that's
themselves
actually
running
collected is distributed.
and pay
is
for all of
designated
this.
for a
Designated.
in a particular
oversight.
fiscal year.
How important is the distribution?
The money that they collect
part of
helps
this
them
analysis to
oversee
your
these
argument?
companies.
I mean, I had
I'm
understood
okay with that.
that you
It's not like
were
this is going home with somebody.
differentiating disgorgement from civil penalty. So just in a very simple analogy, this defendant steals $1 million from a bunch of people. And disgorgement would say,
Try to be
you
optimistic.
can't keep that $1 million. the court could both order him to give back the $1 million that he stole and fine him for having engaged in that behavior. That would be the civil penalty part, right? It's coming out of his own pocket. It's making him worse
should
off
be optimistic.
because he's now fined, or a civil penalty. And you're saying you'd have to have a jury trial for that part of it, the penalty part. Is that correct?
We would have to have a jury, even under our view that disgorgement wouldn't require a jury. If you were seeking civil penalties as well, that you would need a jury.
Okay, so we have $1 million ordered to give back. We have, let's say, $100,000 fine. You'd have to have a jury trial for that part of it. In terms of the give back, is it your position
Civil asset
that
forfeiture?
whether that money goes to the victims or goes to the government, that's really not a key aspect as to whether or not disgorgement can
I will
be
come back
ordered?
to, I'll make a
It's
note,
key
come
under
back to civil
D5,
asset
but not
forfeiture at the
under
end.
D3A2 and D7.
I have a story.
It's really not relevant at all in our view under D3A2 and D7. And the reason is traditional equitable principles are not limits on Congress's power. The reason that traditional equitable limits played a key role in lieu was that the statute itself referred to equitable relief. And so to determine what sort of remedies Congress had implicitly authorized, the court looked to what courts of equity had traditionally done. But Congress can always create new remedies or adjust the terms on which existing remedies will be available. And that's what it did in D3A2 and D7. It said, you can get disgorgement of any unjust enrichment that is received by the defendant as a result of the violation.
As distinguished from I'm sorry, go ahead. As distinguished from D5, which really said something about benefit of the victims.
It had two pieces of operative language. First was there was language at the end of the provision about for the benefit of investors, and the court in lieu also suggested that just the reference to equitable relief might require some effort to compensate victims because that was the way it was typically done. The other point I'd make is—
Mr. Stewart, before you go to another point, I just want to capture this one. Do we even need to decide that question? You said we don't need to decide the Seventh Amendment question if you keep the money. Do we even need to decide whether D7 authorizes you to keep the money? To answer the question presented is just simply, do we need to show injury to the investor? We could answer that hypothetically in your favor, no, without deciding the scope of whether D7 permits you to extend beyond equity to keep the money. Couldn't we do that?
I think that's correct. The other point I was going to make about lieu and about typical equitable practice is that when Liu was asking what courts in equity had typically done, they looked at a broad range of cases involving different subject areas. And because most litigation in this country is private litigation, the court in lieu looked mostly at private suits. And in private suits, it's understandable that any money recovered from the defendant is going to pass to a victim, because the only person who's a proper plaintiff is going to be a victim, someone whose own rights were violated by the misconduct or who is injured in some way by the violation. And it's normal in private civil litigation that there is an award. If there is an award that the defendant paid money, it will be paid to the victim in order to redress his injury. And so those are good reasons in private suits to expect that the money will go to victims. And when Congress was drafting a disgorgement provision specifically for SEC enforcement suits, it needed to decide to what extent do the rules that have applied in private suits translate over into SEC enforcement actions. And with the other two restrictions this court had announced, Congress incorporated them into the statute. It incorporated the term unjust enrichment to make clear that it's net profits, not gross receipts. And it incorporated the limitation that we can get disgorgement only of unjust enrichment received by the defendant. And both of those really go to kind of the core purpose of disgorgement. Disgorgement is intended to ensure that the defendant does not profit by its own wrong, but it's not intended to go beyond that by making him worse off than if he hadn't committed the violation. And the other limits that the court announced in lieu were intended to draw that line. And therefore, it's understandable that Congress incorporated those into the new SEC-specific statute, but didn't incorporate a limitation that the money has to go to victims that seems more in keeping with what we would expect in a private suit.
So if I could just understand, you've been talking about this, but your decision to lead with D7 rather than D5? I guess my question is, like, what are you worried about on D5? Why do you think that D7 is a better argument? Why do you think that D5 is a comparatively weak one?
I mean, I think the biggest problem from our standpoint with D5 is the question that the court left open in lieu, namely, under D5, can we get disgorgement if it is infeasible to distribute the profits to victims, the disgorgement to victims? And the fact that the court left it open means there's some possibility that we would lose that issue at the end of the day. And that would put kind of a substantial damper or potential damper on our disgorgement efforts, because there would be lots of questions about, is it feasible? Mr. Geiser is arguing that if the only victims we can find are people who didn't suffer pecuniary harm, then it really isn't feasible to pass along the money to victims because they don't qualify. And so part of the value of D3A2 from our standpoint is it just takes that question off the table. It says you can make the defendant surrender his unjust enrichment net profits so long as they are profits that the defendant received and so long as he received them as a result of the violation, with no inquiry into where the money is going or where we could have routed it if we had wanted to.
But that would make it a legal remedy.
Mr. Stewart, I'm a bit confused by your answer for the following reason, okay? If we go your route, D7, then the Seventh Amendment issue looms large, because then the government keeping the money and not paying over to victims as compensation, okay, then serves only one purpose: deterrence. And if it's only deterrence, I think you have a much harder way to go to say that it's not a Seventh Amendment violation, to let the judge decide it.
I guess kind of looking ahead to a hypothetical case in which we were litigating the Seventh Amendment question, we'd say a couple of things about that. The first is the paradigmatic equitable remedy is a prohibitory injunction, and a prohibitory injunction has no legitimate purpose other than to deter the defendant from future misconduct. And so I don't think the court would stick to a rule, a categorical rule, that if deterrence is a substantial motivation, the remedy can't be equitable. The second thing I'd say is 11 years ago in Kansas versus Nebraska, this court, exercising original jurisdiction, ordered disgorgement as an equitable remedy and fixed the disgorgement amount at an amount greater than.
But that was the victim receiving the money.
The victim did receive the money, but the court fixed the amount at a sum greater than the victim's loss.
Well, that's because I agree with you that at equity, you could measure the victim's compensable damages by unjust enrichment by the defendant. No question. And windfall profits have always been recognized in equity for unjust enrichment or disgorgement concepts. But if the government is receiving the money, what legally protected right did you have to the money?
I mean, the point I was going to make is the court in Kansas versus Nebraska, in explaining why it made sense to set the disgorgement award at that amount, said it will provide additional deterrence to future breaches of the compact. The parties were in an unusual situation where the water was more valuable to the upstream Nebraska.
I'm accepting that if you are a victim who has a legally invaded right, you are entitled to also deterrence. But if the government is keeping the money, what legally recognizable right is it protecting?
It is simply accomplishing a public interested effort to deprive the defendant of his unlawful profits.
For purposes of deterrence, not compensation, that's my point.
I think substantially for purposes of deterrence, but I think kind of independent of the kind of the utilitarian justification, there is a sense of that it is inherently unfair, inherently inequitable to have an adjudicated violator and say, you can keep the money. But then the other point I'd like to make in response to your question as to why in some circumstances we like D3A2 better is that if push comes to shove, we would rather be in a situation where we can get disgorgement but may have to go through a jury trial to get it than to be in a position where we can't get it at all. And the petitioner's argument is that we can't get it at all except to the extent that it corresponds to identified pecuniary losses on the part of
That's
it.
assuming we accept his underlying premises that equity required proof of pecuniary loss. If we disagree with that, that solves the case.
And we're happy to win the case under D5, and we think we should win it under D5 because even looking at that provision, the petitioner's argument goes substantially
All right. Thank
beyond.
you, counsel.
So the reason this is such a big deal, guys, is that Seventh Amendment requires a jury trial for legal remedies, but not equitable remedies. And so if this is the question, is it legal or equitable? And I'm not going to have time in this little break to explain the difference entirely, but
Thank you, counsel.
I will talk about it a little bit more afterwards.
Rebuttal, Mr. Geiser?
Let's go back for
A few
rebuttal.
quick points, Your Honor. The first is my friend says we're trying to make it as difficult as possible to get funds to victims. That is not our goal. Our goal is to simply delineate between penalties and disgorgement. And if the government thinks it's hard to distribute funds, then they do have the option, seek civil penalties. You can deprive us of every penny, including up to gross proceeds that we've collected, or rely on the very inventive, very powerful private securities bar, which is very good at filing lawsuits when someone is actually injured to recover and compensate an injured party. Now, my friend, I think, equivocated a little, but I think the bottom line answer is that the government does not believe that disgorgement requires returning funds to investors. That is a penalty. Then the government is seeking a penalty. It is indistinguishable from penalties. It looks exactly like the penalty in D3, just with a different cap. That is not the way that Congress writes statutes.
like a duck.
And I do think, Justice
like a
Gorsuch,
duck.
you do need to decide whether the government can keep the funds
That
or
means
not,
that it-
because that's defining what is disgorgement. We can't just kind of put it in this empty vessel and say, in this case, they can deprive wrongdoers of profit, but we're not going to say what disgorgement means. We're not going to square disgorgement with D3 and the fact that Congress drew a stark distinction between civil penalties and disgorgement, even though I think that distinction collapses under my friend's read. I don't think my friend has any answer for D9. If Congress's point here is simply to deprive wrongdoers of a gain and has nothing to do with the remedial function, they can keep it, they don't need to pay the funds back to investors, then I don't know why Congress would have been concerned that anyone would have even imagined that somehow empowering the SEC to seek effectively a second penalty, that they were precluding private investors from bringing their own lawsuits. That reading of D9 doesn't make sense. Our reading does. Under our reading of D9, Congress would have been concerned that because the SEC now has separate authority explicitly ratifying exactly what Liu, I think under its best reading, said, to seek fair compensation on behalf of injured parties, that might now be the exclusive way for private parties to recover. And Congress wanted to make clear, no, that compensatory function that the SEC now has doesn't take away the right of private parties to seek that same function. I don't think it's a plausible reading of Congress's amendments in 2021 that they were adopting 2/3 of Liu, and then by negative implication, implicitly redefining in D7 without saying a word about it, the very core of what disgorgement means, which really does have that compensatory function of taking an asset that someone took that doesn't belong to them and it belongs to someone else. We are taking that asset and returning it over. The final point I'd like to make is that if you do look to D3, my friend has said a lot about unjust enrichment, but D3 still says you can seek disgorgement under paragraph 7. If it's not disgorgement under paragraph 7, then you can't do it. You start with saying, what is disgorgement? And then say, this is the amount that you are disgorging. And I think Congress used that language in D3 because it simply was trying to come up with some way to describe the amount that you were taking as a disgorgement remedy and redistributing to an injured investor. If there are no further questions.
Thank you, counsel. The case is submitted.
Okay, so we have a second case now. We're gonna move over to TMV University of Maryland, the lady who went crazy because she ate a slice of bread. This is about a woman who was, I know that's not funny. I know it's not funny, but it felt a little funny. So I'm sorry. Who had she was diagnosed with having a condition where she had psychotic episodes if she was, was exposed to gluten. And when she got into the hospital was like, no, you don't. You are schizophrenic. And so they basically locked her up. They put her under an involuntary hold, and she fought that, and now she's trying to sue in federal court, but she also sued a bunch in state court. And the question is whether or not she's allowed to sue in federal court after having all this stuff in state court. So it's really about a jurisdictional issue, but the background is, yeah. What else did I want to say real fast? Oh, if you guys are over in the tubes, there's like a bunch of you over there. Make sure you've hit like. I would really appreciate it. Like the stream. I'm sorry that last one was a little dry, but
argument next
I
in
really
case
hope I get my video done
25-197
soon because there was
TM
so
versus
much
the
in there
University of Maryland
that
Medical System
was
Corporation.
relevant
Ms.
to what we
Brodeur.
talked about. So,
Mr. Chief Justice,
Oh,
and may it
interesting. I
please
didn't
the
know she was-
court. Over the past century, this court has found
That's
a
why I
lack
knew
of
her name.
jurisdiction under the Rooker-Feldman Doctrine in exactly 2 cases.
Rooker-Feldman, that's the
Rooker and Feldman.
big thing this is all going to be
In
about.
both, the plaintiffs sought to
Oh, thank
challenge
you
a
very
final
much, Big
decision
Pink
from a
Bird Lady.
state high court, and both cases held that Section 1257 gives only this court jurisdiction over that kind of judgment. Most recently, the court said the Rooker-Feldman Doctrine should be confined to cases of the kind from which the doctrine acquired its name. Yet lower courts haven't heeded that message. Some continue to apply a jurisdictional bar far beyond Rooker and Feldman.
Here's the thing. It's apparently
But
used
the correct
a
rule is
lot
this.
because nobody totally understands what
Rooker-Feldman
it means.
applies only to cases that seek review and rejection
Very
of final
confusing.
judgments of state high courts. That rule follows from text, history, and structure. On text, Section 1257 is the statutory hook for the doctrine. That statute gives this court jurisdiction over final judgments of state high courts, and so by negative inference denies the same jurisdiction to district courts. But Section 1257 says nothing at all about district court jurisdiction when there's no final judgment of a state high court. On history, district courts have long heard collateral attacks on state lower court judgments in narrow circumstances. Neither Rooker nor Feldman silently overturned that historical practice. And on federal court structure, our rule respects doctrines like preclusion, abstention, and the Anti-Injunction Act. Those doctrines already weed out duplicative cases. There's no good reason for Rooker-Feldman to broadly supplant them. Respondent's rule finds no support in text, history, or precedent. It would untether Rooker-Feldman from Section 1257. It would override historical practice and state preclusion rules. It would transform a narrow doctrine into a sweeping jurisdictional bar, and it would amplify confusion and complexity when jurisdictional limits should be clear and grounded in statutory text. The court should reject that vast expansion of Rooker-Feldman. I welcome the court's questions.
If we could just take a step back, does a district court have appellate jurisdiction?
No, district courts can only exercise original jurisdiction.
Now, is there any difference between a district court reviewing
That's kind of the end of this.
a final decision, say, of an agency or a private organization, as opposed to reviewing the final judgment of a court?
Yes, there are critical differences because if a district court is reviewing a final decision of a court in a collateral challenge, it can't actually take any action with respect to that state court judgment. So for example, it can't vacate it, it can't revise the terms of it. That's a substantial difference from the type of remedy that would be available when a district court is, for example, reviewing an agency action. And
So isn't the argument here or the petition, the action here to undo a previous action of a district court and void as from ab initio? I think that's the language that's used in the complaint.
So it's an effort to collaterally
pronunciation than
attack
I've
that
used.
judgment, Justice Thomas, and we don't dispute that point, but that is fundamentally different than an exercise of appellate jurisdiction.
How would it be different from an appeal?
Sure, so there are numerous ways. When you have a case on appeal, it's a continuation of the prior case.
You're limited to the record that was developed below. You can take action with respect to the judgment that was rendered, so you can actually vacate it or set it aside with respect to the world at large, so it binds no one. And critically, you can relitigate issues. There's no potential preclusion bar on appeal. And in all of those respects, a collateral attack is different. It's a new case. It's not a continuation of the prior case. The record isn't formally transferred over. You can take new evidence and adjudicate the issue. You cannot actually take any action to vacate that judgment or do anything other than declare the rights of the parties before you. So the most we could get in a collateral challenge is a declaration or an injunction that prevents enforcement by the parties named in the federal case, but it wouldn't wipe the decision off the books. And critically, doctrines like preclusion could come into play in a collateral attack and do a lot of the work to prevent relitigation when that shouldn't occur.
I'm sorry. Tell me what the value is to having a federal district court and a state appellate court simultaneously reviewing a state court judgment. What's the value in that? The value is that the federal district court is not limited by the record below, is required to take new evidence to determine what Maryland state law is? Because as I look at as the complaint here, you brought a federal due process claim, but you rely primarily on Maryland state law. You're asking us in an action to decide whether there was duress as defined by Maryland state law, whether the Maryland Declaration of Rights gives any rights to the plaintiff that were violated. And you are asking for the consent order to be declared void and unenforceable. So how is, I don't understand why that's more valuable to separation of powers questions as in terms of how we respect state law judgments.
So I think there are two principal values here, Justice Sotomayor.
I'm sorry.
One is the fact that we have a dual system of state and federal courts. And so as Chief Judge Sutton said in the Vanderkott case, it's a national litigation reality that frequently there will be parallel litigation considering precisely the same issue.
But yes, that's when there hasn't been an attack on a state court judgment, because you're not relitigating
well, and also,
rights,
Sotomayor, the former
federal
Fed
and
courts
state rights
professor?
Issue. You're asking us just to exercise appellate jurisdiction. You dropped all of the cases that were parallel
former
to
Solicitor
the state
General
case,
arguing here?
correct?
So there are still some pending cases, but it's
And I
true
thought
that
they
many
were
of
all
the state
dropped, and the only one was the habeas case that remained.
The case
And in that case, you're asking us only to review the state law question. You're not asking us to relitigate or have parallel litigation
They both taught
on
Fed courts?
the original issue. There
They
I
are.
can see the
This is-
value, because you want two courts to be looking at this and giving us their views on it. But that's not what you're doing here. You dropped all the other
This is sort of her
litigation.
jam.
So there is a significant value in ensuring that federal courts are available to vindicate federal rights, including when state court judgments themselves give rise to that kind of constitutional violation. And here we are asserting
Oh, but
the federal
you
due
do have a
process
federal
claim.
right to go to the Supreme Court.
And what Congress recognized in creating jurisdiction under 1331 and 1343, this was part of the 1871 Civil Rights Act. The civil rights jurisdiction was vested in the district court's original jurisdiction, is that all too often those federal rights were being denied, including in state court. So Congress went in with its eyes open to the idea that these grants of federal jurisdiction would provide an opportunity for litigants who were not able to achieve justice in state courts, including through state court judgments themselves that violated constitutional rights, to come
Now-
to a federal forum.
The states who have agreed with you that it's only final judgments that Rooker-Feldman apply to, they're not really limiting themselves to 1257. They are saying if they're defining final judgment in very different ways. If a final judgment has been rendered by the state appellate courts, if the state action has reached a point where neither party seeks further action, for instance, the losing party allows the time for appeal to expire, and if the state court proceedings have finally resolved all the federal questions in the litigation, but state law or purely factual limits remain. That's not anything covered by 1257. It's broader than 1257.
So the 7 circuits on our side of this split have all required at a minimum that the state litigation
At a
be
minimum, but they
conclusively-
add other definitions of final.
Some of them have a broader conception of finality, and we think that the best source to look for a jurisdictional rule comes from the text of the statute that the
So
court has
why
pointed
aren't
to.
we looking to what state law says? State law treats a trial court's judgment as final, just like a district court's final judgment is final, even when it is on appeal. So why isn't that final for our purposes?
Well, for purposes of identifying jurisdictional rules, this court has always looked to acts of Congress. Under modern precedent, the court has said there's no free-floating ability of the courts to simply pluck a jurisdictional rule out of thin air. District courts instead have a virtually unflagging obligation to exercise the jurisdiction Congress has given them. And so the right source to look for the rule is Section 1257, which is where this court has always—
But as Justice Thomas started our conversation, this is appellate review. This is not deciding a cause of action under federal or state law.
So let me try to be directly responsive to that, because I think it's not remotely possible to characterize the Rooker-Feldman Doctrine as suggesting that all collateral attacks are automatically an exercise of impermissible appellate review. For one thing, that would make Section 1257 entirely irrelevant to the analysis, because as I said to Justice Thomas, we of course concede that district courts can only exercise original jurisdiction. If in fact a collateral attack was an impermissible appeal, you don't have to consult 1257 at all. But that runs counter to this court's repeated recognition, including in Exxon, that Section 1257 is the doctrinal foundation for where the Rooker-Feldman rule comes from.
You mentioned Exxon, and of course Judge Heitens put emphasis on the sentence in Exxon, the "we hold" sentence, that did not articulate the rule in the way you do it today. So I guess my question, to pick up on Justice Sotomayor's questions, is why not stick with what we said in the "we hold" sentence in Exxon, given that it would be problematic to have federal and state court parallel litigation to increase it. As you rightly said, there is federal and state court parallel litigation, but why add to it unnecessarily? Why not just stick to the "we hold" sentence and be done with it? Again, if we were starting anew, maybe your position would have more force, but given what we said in Exxon and given what Justice Sotomayor raised, it's just a question.
This issue wasn't directly presented in Exxon, of course, because as you noted, Justice Kavanaugh, it was just parallel litigation. And so I don't think it would be appropriate to read that sentence as explicitly thinking about the situation of what kind of state court judgments could qualify and resolving that issue against us. And in fact, if you look at the rest of the Exxon opinion, its analysis powerfully supports the argument we're making here. Because first, Exxon said that 1257 is the doctrinal underpinning of Rooker-Feldman, and our rule coheres with the text of that statutory provision, final judgments of state high courts. The second thing the court did in Exxon is recognize that lower courts had interpreted Rooker-Feldman far too broadly. The court said this is a jurisdictional rule, it's a narrow limitation, and henceforth, the Rooker-Feldman bar should only apply to cases that are like Rooker and Feldman. And then it described those cases, and this court recognized in Exxon that in each of them, it was a situation where the losing party in state court sought to challenge a final judgment of a state high court, squarely within 1257.
State Supreme Court.
Is there any rational basis
But
for
that's
that
still
distinction?
Yes, I think the
Causes
rational
the same
basis
problem.
comes from the text of Section
From
1257.
1257, but suppose I don't think that Rooker-Feldman is based exclusively on 1257, but is based in part and perhaps primarily on the fact that district courts are not appellate courts. Then what?
So I think that at that point, it would be necessary to look not only at Section 1257, but also to consult history. One of the reasons why I think it's not appropriate to understand Rooker-Feldman to say that all collateral attacks are inevitably impermissible appeals is because we have a long history and tradition in this nation of federal courts exercising their original jurisdiction to consider that kind of attack when it's on a lower court judgment. We cite at page 11 of our reply brief Smith versus Apple, Simon versus Southern Railway, Wells Fargo versus Taylor. In Smith versus Apple, this court specifically recognized that the district court had jurisdiction to consider the collateral attack on the state court judgment. It's just that there were other doctrines, there the Anti-Injunction Act, that barred a remedy.
Well, reading between the lines, I take your real position to be that Rooker-Feldman ought to be overruled, and maybe there are members of the court who would like to do that, but that's not before us here, right?
Our primary argument is that it's not necessary to overrule it. It just shouldn't be vastly
if we're
expanded.
going to limit it, it has to be limited on some rational basis. And I don't really see a rational basis for drawing a distinction between a case where the state court proceeding has concluded and a case where the state court proceeding is ongoing.
Roberts, Vashon? That's not Kavanaugh.
I mean, in Rooker, the individual's name began with an R. And in Feldman, the individual's name began with an F. So here, the individual's name begins with a T. I mean, could we say, well, we're not going to go any further than Rooker and Feldman, so this case doesn't qualify?
I don't think that Exxon quite went that far, but it did try to make clear that it was a narrow doctrine that should not extend beyond the facts of those cases. And the reason why we think there is a relevant difference and a logical one, Justice Alito, is that Congress in 1257, we understand it to have been channeling claims. If you have a state high court judgment, then only this court can review that kind of judgment. And so by negative implication, the district courts can't. Section 1257 doesn't say anything about these lower state court judgments, and so it leaves undisturbed
But
civil rights.
you don't have the channeling, if you're right. I mean, but what concerns me about your argument is that it seems to undermine what Congress was trying to do in 1257, which, as you just said, was, I think, to have the state courts be the primary original arbiters of these kinds of things and to channel them all up through the state appellate system till we get to the point of a state high court judgment that is then reviewable by the Supreme Court. The problem, I think, with suggesting that collateral attacks can occur by the federal district courts along the way is that it seems to undermine the channeling that was the whole point of 1257.
So I disagree strongly with the idea that there was a desire by Congress to say that federal courts writ large can't exercise jurisdiction to adjudicate federal rights. Those grants come from 1331 and here for civil rights, 1343.
That's not what I was saying. What I was saying is that Congress was establishing an order of operations. To the extent that we have the Supreme Court of the United States waiting until the state courts have exercised their jurisdiction and made their determinations, then fine. The Supreme Court will come along at the end of the day, says Congress, and make those kinds of determinations. What you're suggesting
all the way through state
is
court.
that collateral attacks on the basis of the federal issues can be occurring all along the way as the state court is adjudicating this. And I just don't understand how that's consistent with the system that 1257 seems to envision.
So I think that that inference that Section 1257 is meant to occupy the field is more weight than it can bear. Jurisdictional rules are supposed to be clearly expressed, and all that 1257 says is that this court may exercise jurisdiction over state high court judgments. But the statute doesn't say anything about lower court judgments.
Well,
I want to be responsive
on
to this.
On that, I just want to follow up on that before you leave that point.
Batman?
I guess I expect Ms. Blatt to come up and say, well, okay, you want to talk about let's talk about 1257. And you're right, it only authorizes us to hear appeals from high courts, and so that's the negative implication. But maybe another negative implication of it is we can't hear anything from lower state courts. And so isn't that negative implication worthy of respect too?
So I think that that is a far broader negative implication because it doesn't actually hang on any text in Section 1257. And Rooker-Feldman's already at the outer bounds of how this court thinks about jurisdiction.
I hear you on that, okay? And let me explore that for a second. So I know your client doesn't want to probably admit that all the claims here are precluded by issue and claim preclusion. But your friend on the other side is going to argue, we have to have Rooker-Feldman to protect federalism and state courts. But would you concede that artful pleading can't get around issue and claim preclusion principles?
Yes, exactly. And it's an important point, Justice Gorsuch, because a lot of the concerns that have been raised about collateral attacks or having federal courts come in and regularly superintend state courts are directly addressed by preclusion doctrine and by the Anti-Injunction Act in many cases. And there's always abstention doctrines as well as a backdrop.
Why are those I'm sorry.
Sorry, just a few more. I'm almost done. And then the weird thing about Rooker-Feldman is it strips us of jurisdiction to even consider those kinds of questions.
That's right, and it actually runs counter to federalism values insofar as it does so, because under the Full Faith and Credit Act, federal courts have to apply state law rules of preclusion. So that's a gauntlet you have to run.
And
But
some of those are going to be lower, apply to lower courts. Some are going to have to wait till they're all different.
Exactly, and it's only a very narrow circumstance where you can raise this kind of collateral attack to a state law judgment. There's a preclusion principle called the collateral attack rule. Maryland recognizes it, and it generally bars collateral attacks like this one with only very limited exceptions that are reflected in the restatement second of judgment, 69 and 70.
The last one, and then I'm done. Give me your best shot for overruling Rooker-Feldman. I know it's in your brief. I know you don't want to talk about it primarily, but I want to hear them.
Sure.
Sing a few bars for me.
We think that Rooker-Feldman is egregiously wrong. It's out of sync with modern precedent about how the court articulates jurisdictional rules. District courts are supposed to exercise the jurisdiction that Congress gives them, and the court doesn't have a free-floating judge-made power to take away jurisdiction where it exists. So the relevant place to look is in statutory text. And if you look at Section 1257, all it does is say that this court may exercise jurisdiction. It doesn't say that district courts are forbidden from doing so. That's even with respect to the category of judgments this court can review.
I'm sorry, Justice Kagan.
No. Please. If you look at, you said preclusion principles, abstention principles, Anti-Injunction Act.
Sing a few
Why
bars
did those
for me.
create a more sensible system? You know, if you figure that they will operate a good deal of the time, why should we look to those various mechanisms rather than this kind of flat rule of Rooker-Feldman?
There are two reasons to prefer those doctrines. The first is that they're directly tailored to this kind of situation. So they're intended to mediate between overlapping jurisdiction and make sure that there's a sensible order of operations. The collateral attack rule is specifically designed to deal with collateral attacks on prior state court judgments. And so they're specifically designed for this task. And under the Full Faith and Credit Act, it advances principles of federalism to give effect to state law rules of preclusion in the first instance, rather than to have this heavy-handed jurisdictional rule that's going to come in and supplant all of those state law judgments about when claims should and shouldn't be precluded. And that's actually the second reason. The court has said that jurisdictional rules are strong medicine because they carry all the consequences of not being hinged to party presentation. The court has to consider them sua sponte, so there's no waiver or forfeiture. They can be inefficient because you might realize it at the end of the case and then have to undo everything that came before. And critically, you have to resolve them first. So you can imagine a situation where there might be a very easy basis to conclude that this particular suit is precluded under state law. You're not going to be able to make out your claim at the end of the day, but the Rooker-Feldman issue is quite complicated, and it has confounded the lower courts in thinking about exactly what it means to review and reject a state court judgment and when it qualifies. And in every case,
there are a lot of things that have confounded the lower courts on Rooker-Feldman, but I'm not sure that this question necessarily is one of them. And I can understand point of view that says, like, look, what we said in Exxon was this far and no further, and we're tired of this.
Yeah, good stuff.
But Justice Alito also has a point that to sort of, draw the line here is it's not what's created the confusion, really, is this line.
So I agree that our rule is not going to totally clear up all the confusion in the lower courts, but I think it's going to go a long way towards solving part of the problem. It creates an easy gatekeeping measure at the outset. You say, is this the kind of state court judgment that falls within 1257? Is it a final judgment from a state high court? If the answer is no, as it clearly is here, you don't have to think about Rooker-Feldman again. And so it's going to, at the front end, I think, weed out a lot of cases and mean that you don't have to go on to some of those more complex questions in other cases.
But
Ms.
why
Prelogar,
here?
There's a distinction between saying subject to further review or high court. Have the lower courts, who are more on your side of the split, tied it to that state highest court, the apex court, from which we would have jurisdiction under 1257? Or have they said kind of this line subject to further review, like appellate proceedings are ongoing? Which is your situation here?
So they have, many of them, adopted a view that if the state proceedings have ended conclusively, for example, you failed to seek review from the state high court, then it's possible that Rooker-Feldman can apply. Our view is that to be faithful to Section 1257, it really should be limited to decisions from state high courts, and that doctrines like Preclusion or the Anti-Injunction Act are largely going to stand in the way if you don't seek your reviews all the way up through the
How
state court
many
system.
lower courts have gone as far as you in drawing the line there, the apex courts?
So we ultimately have 7 courts
seem
on our
weird.
side on the question of whether you can have Rooker-Feldman when there are state court proceedings ongoing. With respect to those that have limited explicitly to state high court decisions, I don't know that we have a court that's gone that far. There was a very influential First Circuit decision that had a slightly broader conception of finality. But regardless, we win under the rule of those 7 circuits because here there's clear state court proceedings ongoing.
Why pick your rule instead of the proceedings ongoing?
So I think that our rule is more consistent with the text of Section 1257. Now, I acknowledge there is a lot of language in Exxon that talks about, in describing Rooker and Feldman themselves, that the state court proceedings there had ended, but also talked about how what was being reviewed was a final judgment of a state high court. So I think there's kind of language potentially in Exxon to support both of these positions, but that our rule is most consistent with the statutory grounding for the rule.
As Justice Alito said, the high court point of it really wasn't the key, because if it was, I think they would have just said that in Exxon. I mean,
No one briefed it, Justice Jackson. It just wasn't relevant in Exxon because there wasn't any state court judgment at all. So I think, to put myself in the shoes of the court at that moment, they might not have been thinking about this follow-on question. But the clear import of Exxon is this doctrine has been wildly expanded in the lower courts, and that shouldn't happen anymore. And we're seeing a repetition of that now with the lower courts consistently bringing up Rooker-Feldman in cases that we think are far afield from the facts of those cases.
why is it fair to assume from 1257, which, as you've said, says that no federal court can review judgments from the highest court other than the Supreme Court? Why does that necessarily mean that federal district courts can review state court judgments from lower courts? I just see this as an enormous leap. I'm sorry, Mr. Chief Justice, can I keep going?
Sure.
I see that as an enormous leap, and I'm just trying to understand your assuming that.
Of course. So our argument is not that the district court jurisdiction comes from 1257. It's that it comes from 1331 and 1343. Those are broad grants of federal question jurisdiction and civil rights jurisdiction, and here we're raising a federal question in a 1983 claim. Then the question becomes, does Section 1257 do anything to withdraw part of that jurisdiction? That's how the court put it in Exxon. It said, what Rooker-Feldman does is it operates by negative inference from 1257 to take away from district courts claims that they are otherwise empowered to adjudicate. So I think that's how you get to our rule. The text of Section 1257 withdraws only jurisdiction over final judgments from state high courts based on this inference that those judgments are given to this court alone to review.
Thank you, counsel. Justice Thomas? Justice Alito?
So it's not about granting, it's about
You
withdrawing.
did mention to Justice Barrett Feldman footnote 16, which you call dicta, but whether it's dicta or not, it does say that your limitation to final decisions on the legal issues is not necessary.
No, I think that footnote's consistent with our position. It's hypothesizing a situation where you do have a final judgment from a state high court. That's our rule. And that footnote was directed to a situation where the federal question hadn't been raised. And what the footnote said is, in that situation, Rooker-Feldman can still operate as a bar. But that's consistent with our rule
But
because
they could have relied on issue preclusion or claim preclusion principles, but they didn't. They said that Rooker-Feldman could still apply.
Because I think that they were drawing the inference from Section 1257 that even if there might be other reasons this court doesn't grant cert, maybe there's no Article III standing from the petitioner if it came up in state court, or maybe there's an adequate and independent state ground, that's not enough to conclude that there's no Rooker-Feldman bar. But the absolute indispensable requirement, which was present in footnote 16, is final judgment of a state high court. And I want to touch on this idea of preclusion, Justice Sotomayor, because you have asked about why it would make sense to have collateral review. Again, we think that there is going to be a real narrowing of the opportunities for collateral attack under those preclusion principles, but it's important in situations to have access to a federal court where it can apply those state laws of decision. And having a jurisdictional bar come in at the outset is going to displace all of that analysis.
Justice Kagan?
And what do you make, Ms. Prelager, of the references to 1331? 1257 is obviously the predominant rationale, but going back to Rooker, and then in Verizon Medicaid, there's a sentence that's then quoted in Exxon itself, which suggests that there's this sort of second rationale for it, which is based more on 1331 and the difference between original and appellate jurisdiction. Now, if you thought that that was the rationale, presumably you wouldn't need 1257, so why bother talking about that? But it is a little bit odd, right, that in addition to the 1257 language, there's this second strain, if you will, which focuses more on 1331.
So I have been rereading and reading those sentences about appellate jurisdiction, and I think maybe what the court was aiming at in that language is the idea that you do need to have a litigant seeking review and rejection of a state court judgment. So something that's kind of akin to appellate-like review, or the court has said in substance, something that looks similar to what you might get on appellate review. And maybe that language was meant to codify this separate requirement for Rooker-Feldman to apply, that you be seeking to actually have that review and rejection. But I think it's not tenable to read those stray sentences as instead suggesting that a collateral attack is automatically appeal, because that would be inconsistent with the Section 1257 rationale as you just articulated. It would also be flatly inconsistent with history. There are any number of occasions when federal district courts have entertained collateral attacks on state court judgments that's never been thought of as an impermissible appeal. The same can be true with federal judgments. Sometimes federal courts are asked to review collateral attacks on pre-existing federal court judgments. No one says that Rooker-Feldman could come into operation there or that that's an appeal. And it's also just inconsistent with the actual reality, because there are so many differences between appeals and between collateral attacks, both with respect to the remedy you can get and with respect to the application of preclusion doctrine.
Thank you.
Justice Gorsuch?
Yeah, I've never really understood that rationale, the appeal rationale, because litigants are sometimes vexatious. Now, I'm not accusing your client of that. But they repeat suits all the time, sometimes in the same state court, sometimes in a different state court, sometimes in a federal district court, sometimes between two federal district courts, sometimes between two federal district courts in two different states. And all of those we handle under preclusion, and we don't accuse the court, the second court, of exercising any kind of appellate review over the first court. Help me.
That's exactly right. And it just demonstrates that there's no need to have a dramatically expanded domain for Rooker-Feldman to deal with concerns about managing competing or overlapping litigation or parallel disputes like that. Claim preclusion is going to knock out a lot of those cases, because if you could have raised the claim in the prior suit, then you can't raise it here. Issue preclusion, if it's actually litigated, is likewise going to operate to prevent relitigation of some of the issues that were actually decided. And then critically, this collateral attack rule is directly relevant here because it comes into play when you have a pre-existing judgment, and there are only very narrow circumstances like fraud, duress, or a lack of jurisdiction in the underlying court where you might be able to get that kind of judgment set aside. But in no instance is any of that an impermissible exercise of appellate jurisdiction.
Justice Kavanaugh?
If we think 1257 and 1331 don't dictate an answer, and we look at Exxon and it doesn't dictate an answer, and we're just trying to figure out, okay, this is a judge-created doctrine, what makes the most sense here systemically? Why does your position make more sense if it's going to create lots of duplicative litigation in federal and state court that, by your own admission, is usually going to fail because these other doctrines are going to toss it all out anyway? Your position seems to be, let's make sure the federal courts are open just so the federal courts can toss it out on other grounds. So do you want to address that systemic question?
Sure. So I think that systemically it is better to rely on the pre-existing doctrines like preclusion, abstention, and the Anti-Injunction Act, in part because it can advance federalism interests insofar as it gives effect to state law judgments about exactly when preclusion should apply. Our particular suit is not precluded because Maryland has made a judgment that if you entered into a consent decree pursuant to duress, you should be able to challenge that. And yet under respondent's rule, the federal courthouse doors would be entirely closed to that
later
kind of
said
claim, and that disserves interest in
that
federalism.
consent agreement
it also
violated
disserves
her
interest in
constitutional rights,
respecting the lines that Congress has drawn, both through the Full
which
Faith and Credit
included
Act, which is
agreeing
what
to
gives
change
effect
doctors,
to state law
'cause
judgments,
her doctor
and with the Anti-Injunction Act, which is likewise meant to try to address the situation and determine
said
when
bread
federal
made her
courts
crazy.
can and cannot enter remedies with respect to state court proceedings. And here again, respondents' rule would supplant that. And if I don't have you convinced with those two arguments, let me just add that there is a real problem with doing this through jurisdiction insofar as the Rooker-Feldman question might be very difficult and the preclusion issue might be simple. And this rule would vastly expand the circumstances when district courts are going to have to do that complex analysis and think about whether it's review and reject or whether this is actually a state court loser where there are any number of circuit splits, when it might just be very simple to say, this is a precluded case, and so we can reach the merits and dismiss it on that ground.
More specific question, the American Medical Association amicus brief says your position's going to encourage plaintiffs with baseless medical malpractice claims to pursue parallel litigation,
very good point.
run up insurance costs, create the burgeoning cost of health care. I just want to make sure you've responded to that amicus brief.
Yes, so that amicus brief ignores entirely the application of preclusion doctrines, and many of the circumstances that the amicus brief touches on are ones where we think there would be obvious bars based on claim preclusion and issue preclusion. So our argument is not that litigants should always be able to get a do-over and be able to succeed on a collateral attack, but at the same time, there is a strong constitutional value in giving effect to Congress's judgments about the federal court jurisdiction and in assuring that there is a federal court forum at the end of the day to adjudicate that claim.
Thank you.
That's true, Joe Kelly.
Just one question. Under your theory, what would happen if the case was actually on review in this court, and then the litigant also filed a collateral attack in a district court?
So I think that at that point, if it's actually on review in this court, then it's a final judgment from a state high court, and therefore the collateral attack couldn't go forward under Rooker-Feldman, because that is the kind of state high court judgment that we agree, under the reasoning in those cases, creates the bar.
Sorry, I guess I should have meant like your real view that Rooker-Feldman is wrong.
So I do think that Rooker-Feldman is wrong, and it means that there wouldn't be a jurisdictional bar to the exercise of district court jurisdiction. But of course, it's not unusual to have district courts sometimes have jurisdiction to consider the same legal issue, and they issue stays. Exactly. They don't go on to resolve the dispute when it's before this court. And if it were the exact same judgment that was, being challenged,
Yes.
I can't imagine a district court wouldn't rely on these kinds of abstention-like doctrines to mediate that type of conflict.
Thanks.
Justice Jackson?
So I guess I think that the answer in this case may actually rely on what or relate to what we think the real purpose of the Rooker-Feldman Doctrine is. And I've heard you float a couple of theories, and some of them relate to the use of the appellate jurisdiction principle, and is that really what's going on here? But as I read it, it seems as though the court was really trying to advance a certain kind of federalism principle. The court says, if the constitutional questions stated in the bill actually arose in the cause, it was the province and duty of the state courts to decide them. And their decision, whether right or wrong, was an exercise of jurisdiction. And so it goes on to sort of underscore this idea that I think is consistent with the 1257 design, that what the court thinks or thought in Rooker was that the state courts should really be given an opportunity to weigh in on these issues, even though they may be federal in nature. And what concerns me then about your rule is that I'm wondering whether we're not disincentivizing state court losers to actually proceed in the state system. It seemed as though the court in Rooker was trying to say the state court should have its opportunity. Eventually it'll go to the high court, and then it will come to the Supreme Court. And if that's really the thrust of it, why would anybody stay in the state system and get all the way to the state high court under your rule when they could just bring a collateral attack along the way? It just seems to undermine the whole point, in my view.
So I have related answers to both prongs of that question. The reason why litigants are going to stay in state court is because they won't face a preclusion bar. They're allowed to litigate their appeal without facing that heavy hurdle of being
But you're
very
assuming that. I mean, there are many situations in which, and I won't go into them, but we looked at Younger, we looked at Colorado. There are narrow circumstances in which those preclusion bars actually apply. So it isn't automatic that you wouldn't be able to bring a collateral attack. In fact, I think you should be able to bring a collateral attack, which is why you're here.
It's certainly true that we're not saying that collateral attacks will never be permissible. I do think in the mine run case, there will frequently be claim and issue preclusion defenses. But let me try to be responsive to the idea that this is all about federalism. Exxon took a look at this as well, and what the court said there is Rooker-Feldman should not operate as a supersized rule that is meant to override state law preclusion doctrines. Instead, it has a very limited and cabined focus that's tied to Section 1257 and tied to the facts of Rooker and Feldman themselves. And it's not meant to be this kind of one-size-fits-all solution to potentially duplicative or parallel litigation and the problems that can ensue with that. So, and as I've mentioned before, I think from the federalism standpoint, there really is a value in giving effect to those state law rules of decision.
Except if you're a state law, you admit that the state court loser, by the time they get to the high court, Rooker-Feldman applies. So you're saying they're going to continue to litigate, I guess, up until the point that they get to the high court. That's the peculiar thing about your rule, right? I don't understand why you would keep going all the way up to the state court, because that's the point that you say that Rooker-Feldman kicks in.
Because abandoning your state court appeal means abandoning being able to litigate it without claim and issue preclusion, which really are going to knock out a lot of collateral attacks.
In that way.
But on the flip side, just thinking about the flip side of the federalism interests is the access to federal courts interests. And I know that our society has moved beyond 1871 when Congress enacted this jurisdictional grant in Section 1343, but Congress was keenly aware at that time that sometimes state courts were issuing judgments that deprived individuals of their constitutional rights, and it did not want to force them to wait and litigate up through an unjust state court system. It wanted them to be able to get into federal court.
One more question. As I read the question presented here, it does not enable us to look at overruling Rooker-Feldman. That was not a question presented here, and what was presented seems to assume that the doctrine exists. So is that really fairly on the table? I just want to make sure.
So our primary argument, of course, is that the court should not extend Rooker-Feldman beyond state high court judgments, and the court could simply say Rooker and Feldman involved final judgments of state high courts. That's what Section 1257 refers to.
No, I understand. I'm talking about the overruling that came up earlier. That's not in the question presented here, correct?
So there have been occasions, like in Dobbs, where whether to overrule Roe and Casey was not in the question presented. Citizens United is another example of that. So the court has sometimes, when it's delved into a doctrine, decided that it makes sense to reconsider precedent. We don't think the court has to go that far here, but we do think that the question presented should clearly be resolved in our favor.
Thank you.
Thank you, counsel.
I think she's super smart. She was respectful. Everything about it was good. It's just there's something about maybe her voice or something that she's a little fast, and I had a little trouble keeping my.
Ms. Blatt?
Mr. Chief Justice, and may it please the court. Petitioner agrees that under Rooker-Feldman, district courts cannot review state court judgments if the state appellate process is over. But petitioner submits that they can review them if the state appellate process is ongoing. Well, that's backwards. The failure to exhaust the state appellate process makes federal intervention worse, not better. Just like in Rooker and Feldman, both 1331 and 1257 bar this suit. As Exxon explains, 1331 grants strictly original, not appellate jurisdiction. Petitioner gives no reason why suits seeking to review and reject state trial court judgments are any less appellate than identical suits challenging state high court judgments. 1257 confirms there's no jurisdiction here. 1257 gives this court appellate jurisdiction over state high court judgments. Petitioner claims that when this court lacks discretionary appellate jurisdiction under 1257, district courts have mandatory original jurisdiction under 1331. Well, that also makes no sense. 1257 stands for two principles. First, Congress channeled all review of state court judgments to this court. And second, Congress wanted no federal review of state court judgments until the state's highest court has had the opportunity to correct any errors. Petitioner's rule flouts that scheme and damages the integrity of the state appellate process.
The question is
Like
if you
petitioner,
start in
litigants
state
could
court,
jettison state court appeals and invoke the mandatory jurisdiction of 94 district courts to invalidate state court judgments.
if you go all the
I
way
welcome
through
questions.
all of the state court options, all the way through
But
your state Supreme
petitioner's
Court,
argument
the
is
next
that,
step is to go to the federal
fine,
Supreme
you have
Court.
the appellate process.
Question
but
is
you
whether
also
you can
have,
go at some point in there,
collateral attack
like
process,
jump over
and
the
they're both
district court all the way
legitimate,
down at the bottom in
and
federal
they can,
court or not.
take place simultaneously. How would you respond to that argument?
Well, I would respond to it in three ways. I mean, that was exactly the dissent in Feldman, and the court obviously did not care what Justice Stevens thought or just disagreed with them. Second, in Exxon footnote 8 says it went and supported our view that said 2254, which authorized collateral attacks, shows that Congress by statute knows how to authorize collateral review of state court judgments. And even there, it seems beyond obvious to point out that 1254 requires exhaustion. So the one time that Congress authorized collateral attacks, it said you had to exhaust state court appeals. Third, we know of no case, and they don't cite any, that says 1331 allows review and rejection of state court judgments. All the cases they cite, and which my other side just said, were all before Rooker. Only one was after Rooker that didn't have anything to do with the question presented. All were before Feldman, Exxon, Verizon, Reed, Lance, and Skinner, that all said that district courts lack authority to review state court judgments. So I guess our view is, unless you got a statute, there's no such thing as collateral review of state court judgments, and that's under 1254.
This is about at what
Counsel,
point in that process you can just
Would you answer the
jump
question some of my colleagues
from
have
state to
asked?
federal.
Why not relying on preclusion and those sorts of doctrines is a better course than just relying on Rooker-Feldman? And number two, this is a case where the plaintiff could have continued with her state court appeal, but put it on stay, correct?
Correct.
So there is a motive to get out of that state court appeal and come here instead, correct?
Right. Well, let me just say a couple things about preclusion. I find it highly ironic that petitioner wants to rely on preclusion in a case where it's conceded preclusion doesn't apply. Preclusion only applies, as my friend said, when the issue has been litigated or could have been litigated. Here, there's a direct challenge to the consent decree that could not have been litigated. It's seeking to void and invalidate it. So like then Judge Rushing said, and we quoted her article both in our brief in opposition and in our red brief on page 40, she comments that the highest time when you need Rooker-Feldman is this kind of case, where preclusion doesn't apply because you're directly challenging, taking a direct review of the state court judgment. And when you don't have preclusion, Rooker-Feldman is absolutely essential to protect the integrity of the state appellate process.
Yeah, which usually
The other thing I would say about
straight to the
sort
Supreme
of that's
Court,
related to
if
this
they want
is
to hear
also
it.
ironic.
That's the thing, though,
about
is if
this,
they're like, no,
whatever
we're not
this is
hearing
on
this,
federal
then-
civil rights. She filed 3 federal cases here. This is one that was a direct challenge, but she filed 2 others. One was a due process federal court challenge that was before the consent decree was ever filed. She also filed a federal civil rights lawsuit, as the Fourth Circuit noticed saying that this violated her federal rights under the ADA and the Rehab Act. And that was, Rooker-Feldman didn't get raised. It was not, dismissed on jurisdictional grounds. It was dismissed on the merits. So as the Fourth Circuit said, you can bring federal lawsuits. You just can't do what this litigant did with the very facts of Rooker.
How do you mean,
seek to declare a state court judgment void, seek to declare it
Ex
void
post
ab
facto
initio,
is
and
only
seek to enjoin the enforcement.
criminal.
So although Rooker-Feldman almost may never apply, it happens to apply and should apply on the facts of this case.
Well, I guess
Ms.
not
Blatt,
really, but it's
if
it's
I
not
look
a-
at Exxon, and this was by a
not really
unanimous
applicable.
court, and by, I'm just going to say the court's leading proceduralist, Exxon clearly said, we're stuck with Rooker-Feldman, but we sure don't have to expand Rooker-Feldman, and this is the end of it. And whatever you might say about this particular rule, if we issue a decision that goes your way, we are basically saying, forget Exxon. It wasn't the end of it. Rooker-Feldman is alive and well. And in the context of what's happening in the circuit courts, it seems like a very odd message for this court to be sending in light of Exxon and in light of what I think, if you read Judge Sutton's opinion and say yes, 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 and then we issue a decision that says what you want us to say, like, where would that get us?
Well, let me start with Judge Sutton, and then we'll go back to Exxon, and then we'll talk about the confusion. I'm just going to read from Judge Sutton's latest opinion, the HPIL. Rooker-Feldman stands for the straightforward proposition that lower federal courts may not entertain direct appeals to reverse or modify judgments. At the very end of his opinion, he cites Rooker and notes that seeking to void a state court judgment is an appeal because it attempts to directly reverse state court judgments. He's talking about, I mean, he never refers to the highest court. He's talking about a direct appeal. I do think that Judge Sutton obviously has a serious concern about it, and that's something he can, take up at the judicial conference. I'm happy to be on a panel with him, with Mr. Chamigan or Mr. Preligar, but it doesn't have anything to do with this case. I mean, all those issues could rely on the state's highest court judgment. On Justice Ginsburg.
I guess I was asking a broader question. Like, even if I accept what you just said, that it doesn't have anything to do with this case, to rule your way in this case sends a much broader message about what Rooker-Feldman is about and how far courts should do what they're doing, which is applying it in a variety of cases in which they shouldn't be applying it.
Yeah, so I'll continue. First of all, the Fourth Circuit was very careful saying it's been 20 years and they've never seen a Rooker-Feldman case, and just because almost none apply, that doesn't mean, that there can't be one. And so the Fourth Circuit has any problem. But on Justice Ginsburg.
You indicate,
that wouldn't be a great...
that they're rare, but all the briefing before us suggests the number of Rooker-Feldman cases have actually increased since ExxonMobil.
Right, but that's true under whatever you do. If you leave Rooker-Feldman as it is, Judge Sutton is still having heartburn because there's people bringing cases that involve the final
I kind of think
judgment.
not. I kind of think if this is a case where we can say, no, really, what we said in Exxon was what we mean. Rooker and Feldman confined to their particular facts, but no further, then maybe the second time around, courts will get the message.
So, no, and again, let's talk about Exxon and then the three subsequent cases. Justice Ginsburg, before she issues a holding, which, as Justice Kavanaugh said nothing about state court judgment. She's a very careful writer, 9-0, presumably.
It wasn't in the case. There would have been no reason
But
to
this is
address
a
this.
question
Yeah,
of
well, I'm going to still read
jurisdiction,
what she said, if that's okay.
ex post
She
facto
said federal
just
district
isn't
courts are
relevant
empowered to
this,
exercise original, not appellate jurisdiction.
this question.
Rooker-Feldman's complaint essentially invited
Rooker-Feldman.
federal courts of first instance to review and reject unfavorable state court judgments. And then she ends all the stuff that you just cited. It ends with the paragraph that cited Verizon, which you already quoted. So that's on page 291, and the last sentence is, Rooker-Feldman Doctrine recognizes 1331 as a grant of original jurisdiction, does not authorize district courts to exercise appellate jurisdiction over state court judgments. And if I can say now three, if we care about precedent, I'm going to give you three post-Exxon precedent. This one was an opinion by Justice Kavanaugh in Reed versus Gertz 2 terms ago. Rooker-Feldman prevents federal courts from adjudicating cases brought by state court losers challenging state court judgments. And that opinion cites Skinner versus Switzer. State court decisions are not reviewable by lower federal courts. And then we have Switzer itself says you can't have review and rejection of state court judgments. Lance, which is my favorite case, says Rooker-Feldman, in effect, the parties there are seeking to take an appeal of an unfavorable state court decision. And I guess I'll go back to my opening. There is no distinction. So all these cases, you might call it sloppy reasoning, but holding is, Exxon says we hold today, and it's not limited. When you've described Rooker-Feldman, you haven't limited it to state court judgments, and petitioner gives you no reason why it's any less appellate when you invalidate the judgment issued by a state trial court.
Well, but the reason is that the primary rationale for the doctrine has always been 1257, which doesn't apply to this case. And there's a few strands of, 1331 language that floats around, but it's basically a 1257 rule, and 1257 suggests that we should draw the line in exactly where your friend says to draw it.
I think it's an upside-down inference to say district courts always have jurisdiction when this court doesn't.
But they're not
It's
in
only
conflict
upside
here,
down, like for a kind of non-statutory argument, like why would you in a world without statutes?
But that's Rooker-Feldman.
But we have a statute, and the statute is 1257, and it's 1257 that has grounded this doctrine from the very beginning.
Correct, and I think as Justice Gorsuch has said, there are two negative inferences you can take. Both of them are negative inferences. You have the common sense one that we have, which is 1257 is a channeling statute. It protects federalism by making sure you can only review a state court judgment, this Supreme Court, once the state's highest court has the chance to correct any errors. Or you can take petitioners' non-common sense one is that Congress anticipated whenever you didn't have jurisdiction, federal district courts did. And that's led to the very confusing doctrine that I think Justice Barrett talked about. If you go that route, courts have tied themselves in knots under Cox Broadcasting, thinking, well, is this judgment final such that this Supreme Court could review it under Cox Broadcasting, but if it didn't follow under Cox Broadcasting, it wouldn't be, and that's the mess that's on the circuit split. When our rule is just you can't review and reject a appealable state court judgment, and this one, is
When
on
you
appeal.
say review and reject, you mean void it?
Excuse me, void,
Void
yes.
it, which is what she's asking.
Exactly. So, yes, our view is that, and we'll take the definition, I mean, it's revises and corrects a judgment of another tribunal, and review and reject. The two forms of relief in Rooker, one was to void the judgment, and in Feldman, it was to declare the judgment unconstitutional. So you have those exact forms of relief here.
So does your rule then turn on the nature of the claim that the party is making or the relief that they're seeking as opposed to something else?
I think it's the latter. Again, the petition didn't challenge that this was an appellate review. Remember, the petition says if we win on this thing about final state court judgments, it's dispositive. So courts have to decide if there's a review and rejection.
No, but Ms. Pregelar says, look, we have this whole other notion of collateral attacks on a judgment that are allowable, and that appellate review is something different. So if we're trying to characterize what's going on here, how do we know whether she's right that we should call this collateral attack, or you're right that this is really an appellate exercise of appellate jurisdiction of the nature that Rooker is concerned
we
about?
just agree with Exxon, the footnote 8, there's no such thing as collateral review unless Congress authorizes, and it did in 2254. And Exxon said that 2254 shows that Congress knows how to authorize collateral review of state court judgments. But if it's review and rejection of a state court judgment, that's an exercise of appellate jurisdiction. And I think I just read you, the 5 sentences that say when you are, you're outside of 1331, and you're into appellate land when you're seeking to review and reject a state court judgment. And we don't even think you have to get into this because the petition, the Fourth Circuit on pages 8A, 9A, 12A, and 13A explained that this was review and rejection and appeal of a state court judgment. The petition didn't even challenge it, said not one whit in the entire petition that went through that, and that came up with it on its opening brief that this is a collateral review. But if you want to decide that, I would say you decided that in Exxon. I mean, there's just, and then again, the cases, that long history and tradition, it stopped before Rooker. It just stopped. 3 of those cases are dealing with scopes of the anti-injunction. 2 are in a defensive posture. That leaves Huntington. So they have one case that admittedly has nice language for them. It was pre-Rooker, pre-Feldman, pre-Exxon, pre-Verizon, pre-Lance, pre-Skinner. I mean, I could keep going. Pre-Reed. So their long history and tradition is one case from 1900, that's old. I mean, that's really old. Let me just check.
Could you speak
Yeah, sorry, I think I got everything.
Could you speak to Ms. Pregelar's suggestion that we should, as a backup, consider revisiting Rooker-Feldman?
This is not Dobbs. This is not Roe versus
Yes,
Wade.
very
The
good.
words egregiously wrong don't even appear in their brief. Rooker-Feldman is obviously not egregiously wrong. I think, as Justice Thomas said in his dissent, it's just a straightforward reading of 2 statutes. But if we're going to talk about overruling precedent, I mean, this case shows why the federalism interests are important when a litigant tries to short-circuit the state appellate process. It's a blow to federalism. And in 7 states, preclusion doesn't even apply until a judgment is after appeal. So preclusion principles would allow in California, Justice Barrett, I think your hypo is this one, petitioner's rule allows you to go all the way to oral argument in the Supreme Court of California. You don't like the way it went, you file suit in federal court. Because there's no preclusion yet, appeals haven't exhausted. So in all the states that don't apply preclusion until the appellate process is over, you can really game the system. And it costs money. She keeps saying about, well, you just apply preclusion. You have to go find a lawyer to go defend in a lot of suits. It's not like people have money grows on trees for hospitals. So you got to go litigate all this when, it's just, in this particular case, she brought 3 federal lawsuits. One of them was a direct appeal. The other 2, weren't. But here it's voiding a state court judgment. So you can't do that.
The petition in this
Wow,
case
my
was
handwriting
filed
is
by
absolutely
a very
unreadable.
experienced and sophisticated advocate. A second question could have been added, should Rooker-Feldman be overruled? It wasn't overruled. When have we reached out to overrule a decision when we haven't even been asked to do it by
Well, I know
counsel?
the states haven't been. I mean, I'm sitting here going to tell you about how hard it is to get a state amici. You got to go through a long process and give them sufficient time. So if we had known that Rooker was on the table, we might have written a different note telling the states to apply because the other side wants to overrule a case that protects the jurisdiction of their state highest court. So you don't even have any state in front of you here. So no, you're not going to overrule Rooker. I mean, I'm sorry, I don't think you're going to do that.
Woo! Well, excuse me.
Not in an April case. Not happening.
Don't dare my colleagues.
Okay. I'm sorry. A little too much. I'm all yours.
Wow.
Anything further on the right here? Anything further?
Thank you.
Counsel.
Someone's got some gasoline in her coffee this morning. Woohoo!
Rebuttal, Ms. Preliger?
Thank you, Mr.
All right.
Chief Justice. My friend has doubled down on the theory that Rooker-Feldman is justified as an exercise of appellate jurisdiction, or that it explains where the doctrine comes from. But that can't be squared with Section 1257 because you don't have to even consult that statute. And critically, it can't be squared with history. And my friend suggested that the cases we've cited where district courts exercised jurisdiction to issue collateral attacks all predated Rooker. But that's why they're so significant. This court in Rooker and in Feldman never grappled with that history and suggested that it meant to overrule it and entirely strip the district courts of any ability to consider in the exercise of their original jurisdiction that kind of collateral attack. Smith versus Apple is a directly on-point precedent here, where the lower court said that it lacked jurisdiction over that kind of collateral attack, and this court said no. The district court had jurisdiction to review that state court judgment and consider issuing an injunction that would prevent its enforcement. Jurisdiction was secured. The problem was a merits issue that the Anti-Injunction Act barred that suit. So I think that that is strong evidence that as a matter of history and tradition, collateral attacks are nothing new, and they've always been understood to lie within a district court's original jurisdiction. My friend also read out several sentences from different precedents, kind of plucked them out where the issue wasn't presented, and suggests that they support her rule. We have a lot of sentences on our side, too. The court has several times referred to high court judgments. It said in Exxon multiple times that the state court proceedings there had concluded. And so we think that the court's precedent likewise can be read our way. But I think it's also worth stepping back here and not losing sight of the forest for the trees and thinking about how this rule operates. Rooker-Feldman is a doctrine of jurisdiction, and it's already at the very outer bounds of how this court thinks about jurisdictional rules. It's not supposed to be a judge-made doctrine. Instead, it's supposed to come directly from Congress and from clear statutory text. And to vastly expand it in this way would run away from the text of Section 1257 and would also come with the huge costs of imposing this jurisdictional rule and all of the baggage that comes along with it in terms of no party presentation and inefficiencies that come from having to adjudicate the jurisdictional question first. It's also completely unnecessary
untrue.
because doctrines like preclusion and abstention are meant to deal with competing or overlapping jurisdiction, and that's how the courts have long handled these issues in our dual system of state and federal courts. Exxon tried to rein all of this in when in a prior situation, the lower federal courts were applying Rooker-Feldman too broadly, but they haven't taken the hint. And we have seven federal circuit courts on our side, and our rule is clear that you can only invoke Rooker-Feldman in a situation where one of the things being reviewed comes from about 51 state high courts. But on respondents' rule, courts are going to have to think about Rooker-Feldman for any judgment involving any of the more than 15,000 state lower courts. That would be a vast expansion of this doctrine. It would be inconsistent with the text of Section 1257. It would run counter to history. It's a solution in search of a problem because preclusion doctrines already guard against relitigation, and it would be unwarranted. So we would ask the court to reverse.
Thank you, counsel. The case is submitted.
Whew. All right. That was a barn burner. I want to start with Volvo these existential questions of the Constitution this time, you're absolutely right. I gotta say, like, when I'm done with this, I have to get ready for tomorrow. But first, I'm gonna go like lie down and let some of this process, because there was those last two. They were both really good. I mean, they were both really good. And I will say that the first lawyer was a little fast, a little hard to like keep up with. Hey, underpigs, but really, really good. So to get to Toad's issue, who said that if it can go to the Supreme Court, it should be able to go to the district court. And the reason that is not correct. The way that the Constitution is set up, the Supreme Court is created by the Constitution. The lower courts, the district court and appellate courts, are created Congress is given the ability by the Constitution to create these lower courts and to restrict them however they want. And so they create them by statute, and they can basically, Congress can decide that district and circuit courts are only allowed to hear contract issues if they want, and nothing else. If that's what they decide, then there is nothing else that's allowed to go to federal district courts. And everything else we'd hear would have to go to state courts. And that is how federalism is supposed to work. Everything in the federal government is limited in jurisdiction, including the court system. And so particularly those lower courts are restricted, and everything else is supposed to essentially be decided by the state courts. So this is the question here: is how much are we saying can only go through the state courts, and when are we allowing things to move over to the federal courts? Now, once something goes all the way through a state court, there's no question that it can then be appealed to the Supreme Court. A state Supreme Court, I hate using the word state Supreme Court because they are not all called Supreme Courts, but the highest state court, whatever it's called, after it gets through that level, then it can be appealed to the U.S. Supreme Court, and that is in the Constitution. But the question of when something that's below that in the state court system can come over into the federal court system, that's where we have all this like inconsistency and have to figure all these questions out, because Congress has complete control over when cases are and are not allowed to move from one to the other. So that is not, now, whether or not it should be or not, that's another question. That is a policy question. That's a question that gets answered by lawmakers, by members of Congress. They get to decide that, and that is beyond my pay grade. But all of it's beyond my pay grade, but it's outside of the questions that get answered by courts. What the court is up to today is deciding what Congress has decided. That's the question. And so that's what they're trying to figure out, because if the goal of Congress was to really limit this to those state courts and say, no, we don't want the federal courts to hear anything in the state court system until it gets all the way through, then that's, then that would be one thing. Then they would say, okay, yeah, no cases in state courts are allowed to be heard until they make it all the way through. Then they have to go to the Supreme Court. And only, these certain cases are allowed to be heard in the lower federal courts, which technically is exactly what happens. But the question here was whether this is one of the exceptions where things are allowed to jump over through these collateral attacks. That's not the right word, but collateral, whatever. But it just isn't as clear as everything's allowed to be heard over there. And part of the issue is that if we're going to set up this sort of a system, if we're going to set up a system that says only some cases are allowed to move over, and then we create sort of a runaround, sort of a way around that rule system, which is kind of what this might be here, then our system isn't working. If we've created a back door to get around the restrictions, then our system is not going to work. If we've intentionally created a certain back door, then That's cool. And so that's kind of what they're deciding here is this an intentional backdoor or is this a cheat? Are they sneaking out the back? So that's what they're trying to figure out. I hope I got that as close to right as possible. I do think it was really well argued. Like I said, I think I'm going to need some time. I'm going to probably have to listen to it again. But this is the whole concept of federalism. The federal government is a government of limited power. I honestly have no idea what's going to happen in this case. There were so many smart things that were said. I need to go back because when I'm listening here, I'm doing like 6 other things at the same time, trying to make sure my computer isn't crashing in the middle like it did twice today and that sort of thing. So sometimes I miss stuff. So I'll hear like a second of something. I'll be like, oh wait, write that down. So I'm going to go back and probably listen to it a couple more times before I have a really solid answer to that. Because there were so many little bits and pieces that I want to kind of work my way through. But this is all part of this big federalism puzzle that originally we had 13 or now 50 individual governments that had complete control to do everything themselves. And they agreed as a group to let certain things, I'm going to hit equity, don't worry, to let certain things out of their control. We're going to let this thing and this thing and this thing be controlled by this central government, but only those things, nothing else. And that's federalism. That is the thing that says we are going to let this limited list of things go to this central federal government, but it is restricted to that small list of things. And that includes in the court system. The state courts are still allowed to hear anything they want, and then the federal courts have just a few limited things that the states have sort of delegated, more or less, to the federal courts to allow them to hear. Now, when I say that, there's sort of a gotcha in there, which there are a few things that the federal court can hear and the state court can't hear, but they are very limited to those things that were on that list. The questions that are related to things that the states originally gave up. So that's kind of the whole idea of federalism. And I haven't done a good federalism video in a while. I love my federalism. My drawing of federalism, I think, is one of my favorite things I ever came up with. So I'll probably do that again soon. Let me talk about equity for a minute. So I've been in the middle, for those of you who haven't heard, I've been working on this massive video now for 3 months. And part of the reason it's been taking me so long is that I keep coming up with new little things. Like today, I've heard one more little thing that I'm want to go in and change. And every time I change something, it means I have to change it all the way through. I have to change it on, now my script is now 80 pages long and covers so many different things. It was not supposed to take this long. But a part of it, because the case that we follow, that we're doing in kind of the second half of the video, is an equity case, as I walk again through equity. And I came up with what I think is kind of an interesting way to think about it, which is that, way, way back in the day, before there were any court systems, when we, resolved disputes by letting people fight to the death, somebody at some point was like, you know what, instead of this whole, instead of battling to figure out who wins, we're going to have John be in charge of figuring out how many apples you have to pay if you break somebody's arm. And so we set up John's court of apples per broken arm. And over the years, John starts coming up with some special rules, like if you got a broken arm, you need to wear a sling into court so we know your arm is broken, because otherwise, we don't have X-rays. So, if you got a sling on there, we'll know. And then we start having all these other courts for sheep thieves and, one for whatever else. Obviously, this isn't the real courts, but And what happens over time is as we start to like merge these courts together, the little rules that were developed, like always wearing slings if your arm is broken, stick around. And so when we have a more general court that hears like 15 different types of cases, you still have to show up with your arm in a sling from that old court, from John's old apple court. And that is the best way I can think of to explain equity. Because equity used to be its own separate court that only answered very specific questions and did very specific things. And today it's been merged into the other courts. But the old rules that were designed for a very good reason at the time still exist. And so the reason that equity had its special rules is that it was a really powerful court. It was kind of like the king's special court where he could sort of do whatever the heck he wanted. And only certain types of questions were allowed in there. Because of that, because it was so powerful and because it really didn't necessarily always give you like a law type answer. It wasn't always like, well, the law says this. It was more like, well, this seems fair. And so if we did that for everything, there'd be no point in having a law, right? Like if all you had to do was go in and convince somebody that your side was better. And equity is kind of like that. It's all about fairness and like that sort of thing. So in order to get into equity, you got to prove that you deserve to be in equity, which is a huge burden to get in the equity door. You have to do a bunch of stuff and prove that you deserve to be in there. And so equity, all of the things where now the law makes you do something or stop doing something are essentially old equity things. And today they look basically the same, but they're still tied to those old rules from back when it was its own court, just like if you had to wear a sling into court today. And so equity, any injunctions, any stays, any restraining orders, those are all equity. And disgorgement, because they're telling you to do something. Anything that's like, what do they call it? There's a good word for it, but if they make you do something, the example they always give, which is something they never actually make you do, but I can't remember it, is like forced performance, something like that. But the kind of example where they don't make you do it is if a ballet dancer decides they don't want to dance. Can they make them dance anyway? And they actually can't for a reason, but it would be that sort of thing. If they made you go in and dance anyway. Anything where they make you do something, that is equity. And because it's such a harsh, has so much power to it, you gotta really prove you deserve it. And so this was an equitable remedy. Now the thing about equity is, unlike law, which is common law, we don't necessarily, because it's so complex and because it has so many weird little rules and stuff, we don't want it being handled. We want it being handled by an expert. We want a surgeon managing equity questions. And so unlike common law questions, where we want it to be very democratic, and we want we want the public to be involved in choosing the answer, where we have a jury answer the questions. We're talking about the disgorgement case, yeah. Unlike where we have that equity, we do not involve a jury, and so that's why the Seventh Amendment only applies the jury requirement in civil cases to common law cases and not to equity. So that is, and it, we don't always say common law when we mean it, but it is sort of basically what we're saying. It's from back when we were merging all those old courts, 800, 700 years ago, 600 years ago, whatever it was, Court of Common Pleas and all those old things became kind of the law courts, and the equity court was different. We didn't actually merge them in federal court technically, I think, until 1938. And some states still have separate equity courts. Why did they change? It was super inefficient. And it didn't change everywhere. Delaware famously still has its chancery courts. Mississippi, I think, still has chancery court. Tennessee maybe still has chancery court. Chancery and equity are the same, named because the guy who was in charge in England was the chancellor. That was the guy in charge of the equity court. It was the king's kind of personal court, and he would, name the chancellor. And the doctrine of clean hands comes from equity because, again, you got to prove you can walk in the door. You deserve to walk in the door, and so you need to walk in there with your hands clean. Nobody can walk in there having any inkling of having done anything shady and still get into equity, because that would not be cool. It's only people who come in there with big angel wings can get into equity court. And so the doctrine of clean hands requires... Wyoming has a chancery court. Interesting. Okay. New Jersey. All right. So they're around a lot. It's weird because when we are in law school, the only example they give you of an active chancery court is Delaware. Everybody's like, oh yeah, but all the chancery courts are gone except for Delaware. And now I'm finding out there are tons of them. Well, part of the reason that these are different in every state, part of it is just how we're set up, this federalism system. But there's this old concept that we are, we are 50 laboratories of democracy, because each state is its own lab, trying out all of these different little experiments all the time to see what works and what doesn't, and learning from each other and applying different sets of values and different ideas and trying different things out. And so we become these little micro laboratories of democracy. Is this theory behind, that's why they call it the American experiment. Anyway, was that enough on equity? I could go on. I can quite literally go on for probably 2.5 hours, based on the length of my video that I really just want to get done, and I think you guys are really gonna like it once I get it done. It goes through kind of an explanation of broad concepts of what we do in law, how legal tests are created and applied, how legal interpretation exists, how laws are structured and how legislatures write them, what the difference is between questions of law, fact, and policy, what all of these different things mean, with examples, fake examples first, and then I go back through once we get through kind of all of these different steps, and then what equity is, then we go through the case of Kelly v. Hegseth, the preliminary injunction that was applied or was granted in January, which is when I started writing this damn thing, and go through the entire thing. I am going to whiteboard the entire thing with, I have pieces of it right now with at least looking at one test that is broken into from the main test to a sub-test to 2 sub-branches, to each of those into 2 sub-branches each of those into 3 sub-branches each, and one of those into 2 more sub-branches. So it goes all the way along the whiteboard. It is going to be massive. And I just have to get it, it's almost written the way I want, and then I have to make sure I have the lighting, which is really difficult in front of a whiteboard, to be able to use all the whiteboard without having reflections. And I have graphics as well that I've made for it. It has been so much work. Why enjoining government on a constitutional issue is equity. It's not necessarily. Why saying enjoining government on a constitutional issue? Can you ask that again? I'm sorry. Preliminary injunctions are equitable relief. Anytime it's preliminary injunction, that's equity. Anytime there's an injunction, anytime there's a restraining order, anytime there's a stay, always equity. Disgorgement, equitable remedy. But, and this was, I had this up here, and I think I even wrote to bring this back up specifically for you. Where did I put this? Oh, no, that was a different one. What did I say? Equity is about making people whole. Yeah, making people whole is another thing. Hold on, I'll come back to that. The reason, anytime you tell someone to do something or not to do something, that's equity. In law, what you do is, what you give are called declarations. Common law declares things mostly. Most of the, not entirely, but most. One sec. Sorry, guys. I don't know why this is happening today. I think they may have updated. But the program that I use to stream this has crashed on me like 3 times. Do you have audio now? Sorry about that. So before tomorrow, I'll reinstall everything, and hopefully it might be just I might just need an update. I gotta remember now. Oh yeah, right. Declarations. So when you get an answer from common law court, it's usually a declaration. It'll say, like let's say if there was a contract, the common law court will declare that you violated the contract. Whereas the court of equity might force you to complete the contract. Very rare. Very rarely will they do that. What will happen is, for example, you'll get a declaration from the common law court that says you owe $1,000, you have violated the contract and you owe $1,000, and then whoever wins that will have to take that down to the sheriff and get that enforced. The court itself does not actually force you to do anything. It's a little weird, it's a little backwards, but it's just the way it's done. There's way more to it than that, and it feels a little like, really, is this really happening? But it is actually the case. So that's why they said unjust enrichment is a legal issue and disgorgement is sort of the equitable version. Gustav, if you're still here, civil asset forfeiture. I actually tanked a civil asset forfeiture bill when I was an assistant attorney general, and it's one of my proudest moments. I mean, I tanked it. I only found out about it. I want to say it was a Wednesday. I was working on a bunch of other pieces of legislation. I found out that it was going down on Thursday, on Wednesday, just as I was leaving at work, and I printed out a bunch of stuff, took them all home. I did not sleep. I was up all night, and I came in the next morning with like a solid argument, and I went into my my boss's office and just tirade because I was angry and hadn't slept and over-caffeinated, and I just this is why we cannot do this. And he went down to the floor of the legislature and killed it. But basically, I mean, he had frankly, a much better, more pragmatic answer than I did, which was that there was no way, they were talking about doing things like forfeit, civil forfeiture of like cars and things, and he's like, where are we going to keep a car? We don't have any place. We have no practical means of doing this, of enforcing this. So this cannot work. And but I said, this is something that was created in the 70s and is now considered essentially unconstitutional and yada yada yada. But I was on a tirade, and he was like, okay, all right, okay. He's like, okay, got it. And he, put his head into it and came up with an answer that would be, I think, brilliantly way more convincing than mine. One that was not based on, kind of philosophy, but on practicality. Like, we couldn't do this if we wanted to, and went down and tanked it. Went down to the floor and tanked it for me, which I was like, it was one of my proudest, one of the best things I did as an assistant attorney general. And what was I think I got to the end of, does that answer you, Tin Pan? And also, an update for OBS just came out. That's what happens. I need to update it. That's what I figured when I've never had it crash ever, not quite like that. So I was like, I'm going to bet, I have had it crash, but not in the middle of a stream like that. So I was like, I bet they came out with a new version and I haven't updated it yet. But it was in the middle of the stream. There's nothing I was going to do about it right now. Okay. So, but the thing is, so this is why, though, Vashon, what you see a lot is, there was a lot of equitable decisions made over the past year that were overturned on the basis that equity is not supposed to be broadly used. It's supposed to be really rarely used. It's considered, what do they call it? What's the line? It's an extraordinary remedy. Extraordinary. Rarely used, and it was being used every time because it was sort of the only option under the circumstances, but they were like, we can't let this be used. This can't be the only thing you guys are putting out. And so that was kind of the problem. I rather agree with you, Micah, that this is not... But it is what it is. I'll fix it before tomorrow. And one of the things that I wanted to say, I sort of brought this up in the middle. We were talking about this. This is in the first case when we were talking about... when we're talking about... this was, it was a question about securities law and whether it was a violation if nobody lost any money. And the reason, which is why I'm CASA to understand equity, yeah, it was confused. Well, okay, one more thing, I'll come back to that. The reason that CASA was decided is that Justice Barrett said equity is supposed to be rare. Equity is like almost never supposed to be used. So let's go back to 1700s when they brought equity into our law and see how frequently this would be used, what the restrictions are. And she was like, okay, so the restrictions are this. How are we using it? Are we using it like this? So that's it. Okay. So the reason that I said that what I was talking about as far as potentially somebody who sells stocks outside, unregistered stocks, and whether they still have victims or not. The metaphor that I think, there are two metaphors. I used the lemonade stand in my version earlier. It's one of the three I'd originally considered using. The other ones I really like are a casino, where if you're going to put your money into a slot machine, then and pull a thing, we agree you're not guaranteed to win. But in order for this whole system to work, we have to at least make sure that it's not like an actual money pit. Like that there's some sort of chance that you'll get your money back, and that somebody's making sure that that the casino's not lying to you, that that this machine isn't just set to take every single quarter that gets put in there. And so somebody's going to come in from whoever, the Nevada Gaming Authority, and make sure it's set to give back a certain percentage of quarters. And if somebody is running a secret casino, then nobody's checking that. And so whether or not the occasional person wins is sort of irrelevant if you're able to game the system and cheat people one way or another. That's one thing. And so this guy, by selling unregistered securities, was not providing all of the information that we make companies like that provide to make sure that they're not gaming the system. Because when you put money into a stock, when you buy stocks, you have no control about how the company is run. So in exchange, you have to at least be told what's going on in the company. And that's what the registration does. If you're cheating that system, then you're basically running a secret casino in the back of a gas station, and you could be just stealing everybody's quarters. We have no way of telling. The other thing is that even if everybody did get their money back, you still got to, like, I was thinking of a bank that holds onto your money for a little bit and is like, oh yeah, we'll give it to you on Monday. That weekend, they can make money off of your money. And so that's also part of the problem, is that somebody who gets money, even if you don't lose money, they're going to make money off of whatever they had of yours. And so that's also part of the problem, was that he was able to probably make more money off of these people's cash. So that's part of the question. Okay. Yeah, I am at the end of what I got to say. Tomorrow morning, we talked a little bit about the Seventh Amendment, equity versus common law, because common law gets juries and Seventh doesn't usually. And tomorrow we're going to talk about some big fines that were imposed on AT&T and Verizon, and whether or not the fact that they could technically end up in court over those fines and therefore get a jury means that the original fines were not a violation of the Seventh Amendment. Ooh. So, or something like that. It's close. I've still got to get a little better in touch with it, but it's going to be interesting. No, absolutely. So Gustav said something very, very important here. Some politicians don't care about legal theory, so pointing out how it is in practical works, that's very, very true. My goal here is to help you guys recognize when people are straying from the rules. I think it's much easier to tell that when you know what the rules are. Which is why I tend to teach you guys the rules, how things are supposed to work, so that you can better recognize when they're not working yourself. That's kind of, I figure enough people are saying, oh, this isn't working. Okay, cool. But I want you to see it for yourself. And so that's what I'm usually trying to teach. But anyway. Okay. I'm going to go lie down. That was 3 hours. So I will see you all tomorrow morning, 10 a.m. And then there's another one on Wednesday, too, that's also going to be really interesting. It's about something immigration related. And if anybody would like to I've got my all the different ways to. Yep. Yeah. So thank you guys very much. If anybody wants to put some, there's always support me if you feel like it over at the link in my profile or on my link tree, anything like that. I would very much appreciate it. Or you can become a member or subscribe to my Substack or anything like that. Oh, that reminds me. In my Substack, I usually have the links to all the cases that I'm talking about. So if you're interested in that, that's the way to do it. Yeah, hit the likes and all that wonderful stuff. Yeah. 3 in a row this week. Woo! Fantastic. All right, guys. I will see you all tomorrow morning. Bye, everybody.